31st of July under the heading motion.
Lordship.
Both cases, extension of interim order, it will expire on 31st July.
31st extension.
Lordship, old motion matter.
Old motion means?
Lordship, this matter was listed on 8. Even there are no date.
When? 8? When this was listed?
8 July, Lordship.
8 July of this month, this year?
Yes.
So what was the order passed?
No order, but that time service not completed. Now service is completed.
No order was passed?
No order.
Only for direction for giving, effecting service?
Yes.
What is the matter about?
Pollution.
Well, let it appear on Saturday.
Yes.
Saturday?
Saturday.
Yes. Saturday is a good day.
Plus.
Very good. 2nd of August.
My lord, may I permit to mention a matter for extension of interim order?
Extension when expire?
31st July, my lord, this month.
31st July.
Matter is regarding on upper bank. Actually, what happened in Lordship, first August 2025, the next selection process will be started. And I am seeking 8 phase selection process, Your Lordship. And my case is pending, Your Lordship. Kindly do this.
Yes, what do you want?
I want that the matter will be hard on this matter.
What is your case? That it is to be heard? What is the urgency?
I'm seeking this, I'm seeking the 8 phase selection process.
What is
but
the status of your candidature?
The Lordship, the last order. Justice, Honorable Justice.
Tell me what was the order?
Yes, actually it's pending. Your Honor.
Are you a candidate who is a fresh candidate or who has lost the job?
I've lost the job.
Lost the
Then
job. Now what do you want?
Now I'm just.
Why you
I'm
did
the
not appear
participant.
at the relevant point of time? You are working then.
Yes.
So at that point of time, you have did you you must have been invited to participate in the counseling.
Yes, sir.
You did not appear.
That I think there should have some connection with other matter.
Yes, yes. So now how it is become it has become urgent.
No, actually.
Now it has how it has become urgent. You are working, you have lost the job. Now you want that you should be permitted for the counseling. Did you participate in the personality test?
But Your Lordship.
Did you participate in the personality test?
That I have to seek it.
Yes, in obtain instruction. Don't waste court's time in this fashion
Lordship.
without knowing the matter. Yes. Hearing. It's not possible. There are hearing matters in the list. Yes.
May I permit to mention one matter that the matter was been earlier listed and affidavit all has been exchanged, Lordship.
Affidavits exchange,
or exchange,
and
fixed.
now it will not be included because there are hearing matters. Yes.
Stay order
entire stretch of the vote stopped due to the stay order. We have not been got, we are the main respondent to got this land logic. That was the temporary and it's matter is very urgent for me.
In the main writ petition, what was the order passed?
It was still a logic. And the project was made addition was done by the SNIA authority. They have not made the SNIA authority. It's a qualification of this one.
Well, witness day under the heading applications. Serve notice upon other side. Call the list.
Lordship,
I mentioned the matter on the earlier date also. That on Honorable Justice Shubhra Ghosh listed the matter on 9/7/2025. But on that day, it did not come in the list or soon thereafter. So I mentioned it on the earlier occasion last Tuesday. Learned Court told me to come after some days. Actually, it is
What is the present state of the stage of the writ petition? What was the order passed on
the order was passed. Actually, we filed they filed their affidavit.
So it's a
opposition.
hearing matter.
That's the hearing
Affidavits are being exchanged means here is a hearing matter.
Right.
There are hearing matters. If the hearing is progress to certain extent, then I can allow. Otherwise, no.
Then my lord,
Yes.
when should I come?
Lordship, I haven't
No, no,
mentioned, I haven't one mention, the matter, in the matter, Lordship, it is, of course, I am covered by the interim order, But
Are you
there is a
appearing in
difference.
item number 1?
No, mentioning, Lordship.
Why you are mentioning?
Mentioning one matter, Lordship, I need to appear, Lordship may kindly appear, allowed to appear it as for orders for a last chance to the respondent concerned to file affidavit in opposition, because the land, my land is acquired,
It is affidavit in opposition direction. I have not allowed a single mentioning for inclusion.
Oh, Lordship.
Yes,
Lord.
call the list. Yes, call the list.
Your Lordship, I appear for the petitioner in this matter. Your Lordship, this was a matter, if your Lordship sees the last two orders of 14 November 2024, where your Lordship, in spite of repeated directions being sought for by the state, no affidavit has been filed, so their right has been closed.
When the interim order was passed.
No, Lordship, there was no interim order passed in this matter, but I
Matter
was
has
given
come
liberty
under the
to
heading
present.
extension of interim
Yes,
order.
yes, your Lordship, we have
But
mentioned the
why
matter
it
for
has been
listing the
mentioned
matter
for
under
extension
the heading motion.
Why it has been mentioned for
Your Lordship,
extension of
your
interim
Lordship,
order?
kindly-
I have
Lordship,
not
kindly-
mentioned it.
Who has mentioned
No,
it?
Lordship, it has not been mentioned for interim order.
It was mentioned for interim
For
order.
listing under interim.
It was mentioned for interim order.
I was
You
under
do
the
not know
impression it
perhaps.
was mentioned for listing.
It was mentioned for interim order.
Oh, I was not
You
aware.
may
Your
not
Lordship, that
know.
it has been-
So please don't open your
I'm
mouth
very
in this
sorry.
fashion. Wait,
I was not aware, Your Lordship. I was not aware.
why you have mentioned for interim order?
That I am appearing for interim order, Lordship. That's why.
Why you have mentioned this matter for extension of interim order?
Lordship, I am
You
not-
are trying to outwit the court.
No, Lordship, I have not mentioned the extension of interim. I am said that.
Your Lordship,
I
I
am happy to
apologize
Your
for my
Lordship,
learned friend's conduct. Your Lordship, I apologize for my learned friend's conduct. Your Lordship, maybe
Matter has come up in the list under
under
the
the-
heading extension of
mistaken.
interim order on being mentioned by the learned advocate representing the petitioner. Stop. However, at the time of call, it is submitted that there was no, it is not a case of extension of interim order and no interim order is subsisting. Stop. Let the matter go out of list. Next, call the next matter.
I am for the petition.
If you go on this practice, court will mark you
No, Lordship, I will not.
and henceforth court will not permit you to mention this matter.
Lordship,
Any matter.
I apologize.
You are a junior member of the bar. You should know what to mention and what not to mention.
Sorry,
Your Lordship, I apologize on his behalf. Your Lordship, I apologize on his behalf.
Yes, yes, Mr. Mishra.
The affidavit of service is there, the other party is represented, Lord. Lord, the last extension of interim order, Lords, was done on 19th June 2025 for 4 weeks. Within the expiry period, Lord, the application has been preferred, it is being taken up today. Very
Now,
sorry, state of
when the
affairs,
interim order was passed?
on 19th June 2025. Lord, this is the 8th extension that we are seeking,
19 June,
2025.
initially it was passed.
No, Lords, last extension.
No, initially
First
when,
extension was on 13th of March.
when the,
2000
what was the interim order? When the interim order was passed?
First interim order was passed on 13th of March 2024. This is the 8th application in the series, Lords. My request, my Lordship, is either, Lords, to extend the interim order till the disposal of the writ petition, or let them file an affidavit and it can be taken up, Lords, for hearing. Whereas the time for affidavit in opposition has been extended at 5 different occasions, starting from 13th March till 3rd of December 2024. And eighth. Oh, copy, sir. Sir, you are not a party, sir. You are not a party. সেন্ট্রাল প্রভিডেন্ট পার্টি না না না, তোমরা স্টার্টিং থেকে এটাতে অ্যাপিয়ারেন্স লাগাইছো, তোমরা পার্টি না, এটা কোনো বিল পাবে না।
Affidavits are complete.
No, my lords. This is the, today, if the direction is given, my lords, it will be 6th occasion for them to file the affidavit.
Who is appearing for the?
Previous time, my lords, Mr.
Respondent
Bari
number
used to-
4. Respondent number 4, you are appearing for respondent number 4.
Yes, Lordship.
So why you are not filing affidavit?
Lordship, actually, respondent number 4 is now seat in. line
It's a
of the
security
paper.
agency
Yes, Lordship.
providing
yes,
security
yes,
guard.
yes.
I'm for the security.
Gratuity claim. We want to dispose it of, my lord, this way or that way. And my lords, I am covered by the.
No, but the problem is this, since affidavit direction has been given by previous
My lordship,
earlier occasion.
my lordship,
it is
13th
not
March,
Proper,
25th
and on
April.
several occasions, extension has been allowed.
my lords,
Even
how
without
many times,
affidavit,
my lords,
how this court can proceed with?
5 times the extension has been allowed for affidavit in opposition. Let it be taken
So
up on
what to
Wednesday.
file? Respondent number, you have not filed opposition.
No, my lord.
Why?
Lordship,
Because main grievance of the petitioner is against you.
Against it is-
You are the person to pay the provident fund amount in connection with your
Gratuity
employee.
amount.
Gratuity amount in
Gratuity.
connection with your employee.
Lordship.
So why you are not filing affidavit?
Lordship, respondent number 4 now seat in line on the page. That's why I'm not filing the. It Lordship taken up the hearing.
Lords, even otherwise a question of law, my lords, let it be put, kept on Wednesday, my lords, we will dispose it of. Humble request. Now, let there be an extension till
Yes, sir.
disposal of the petition and keep it on Wednesday, my lords, we will dispose it of. We are eager to argue and finish it off.
The application being can 8. Can 1.
Can 8, my lords. This is the 8th time that we are moving for extension.
Application being can 8 of 2025. Is for extension of interim order which was passed on 13th March 2024. 4. Stop. Next paragraph, it is submitted during course of hearing that till date affidavit in opposition has not been used by the respondent number 4. and other respondents. Respondent number 4 is the main contesting.
4 and
respondent.
5. 5 is the person who will get the benefit.
5 is not appearing.
He is not appearing. Not appearing. He is the workman.
Regarding who is the
एक बार
the
एक बार কিন্তু বাড়ি সাহেব দুজনকে রিপ্রেজেন্ট করেছে হ্যাঁ
আচ্ছা I don't know, but আমি একজনের জন্য আছি।
Affidavit in opposition, affidavit in opposition has not been filed by the respondent number 4 and 5 and other respondents. In spite of directing the respondents to file the same. Next paragraph. Next paragraph, no, shall stop here. As a last chance, time to file affidavit in opposition stands extended.
Till the disposal of the writ petition, lords. Lords will take care of the fact. Lords, this is the 8th extension that we are filing.
By 18th August 2025. And affidavit in reply here to any shall be filed by 25th August 20. Stop. Direction for filing affidavits. Now, time fixed for filing affidavit. Now, time extended for filing affidavits is permitted. Next paragraph. This is the matter under the hearing. On the 3rd day of the circuit commencing from 1st September 2025. Stop. Interim order passed earlier stands extended. Interim order is still existing.
No, lords. It expired on 18/7. We filed the application on the last day.
18 July.
My lords. There was a 4 weeks extension from 19 June.
Interim order passed earlier is reimposed. And stands extended. Till 31st October 2020. Or until 31st October 2025 or until further order, whichever is that. Next slide. Learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file affidavit of service on the next date. Next paragraph. The application being can 8 of 2025 stands disposed.
I'm on this.
Over the official is filed on behalf of the applicant is taken on record.
Number 3, not I for this.
Then restoration application. Restoration application. দেখো তো এটা কবে মেনশন হচ্ছে? Nobody is appearing on mentioning matter is who has mentioned this matter, the applicant. You know, both the applicant, one is for restoration, another is for condonation of delay, section 5. Well, not to the. Acha, record an order. At the time of call, no one appears for the applicant and no accommodation is paid for. However, state, you are for the state. State respondents are represented by learned advocate. Stop. Hearing of this application stands adjourned. Stop. List the applications under the same heading on. On 30, on 1st August 2025 for further consideration. Stop. Next matter. However, it is made clear if on the next date applicant goes unrepresented, consequential order shall be passed. Next. Yes.
Yes, Lordship, just this matter, Lordship, it is infractions. This item number 4, I'm looking for Civil Municipal Corporation. I don't know, this matter has become infractions because subsequently, order of demolition was passed that has been challenged. The
If I recall, my lord, this matter was disposed of. I don't know how.
Yes, writ petition is disposed.
Yes,
of,
yes,
correct.
yes.
Ilu ki kori? Huh?
Subsequently, a new writ petition has been filed, which is
947.
which was mentioned.
One
by-
Bapi Sarkar mentioned it.
Sarkar.
Advocate. Issue. Yes, yes, it has been disposed of wrongly mentioned. Matter has come up in the list under the heading motion on being mentioned by the learned advocate representing the petitioner. Stop. Stop. Next paragraph. At a time of call, no one appears for the. At a time of the call, next paragraph. On perusal of record, it appears that video order dated 18 June 2024, passed by a coordinate bench, writ petition was disposed of. Stop. Let the matter go out of list. Stop. Department is directed to treat the matter as disposed of. Good. Next. Number 5.
I'm for respondent number 5, my lord.
What is your instruction?
My lord, as per my instruction, my lord, petitioner suppressed some facts. Likewise, my lord, in 1994, the boundary wall was made in the presence of the present petitioner and his parents, my lord. And it was mutually agreed that while constructing that boundary wall, 0.2 decimal of land of the petitioner came into GP, Gram Panchayat, my lord. And in lieu of 0.2 decimal of land, the Gram Panchayat provided 0.8 decimal of land to the petitioner, which he is enjoying at present, my lord. And that land is recorded in the name of the Gram Panchayat. So it was a mutual
Exchange of land.
Yes, my lord. It was a mutual understanding between the parents of the petitioner and the Gram Panchayat. Then, my lord. Now, my lord, at present, at that piece of land, my lord, one health center is standing, my lord. Even my lord, there is a hoarding that that land has been donated by the mother of the petitioner all over this Gram Panchayat, my lord. They were very generous, the parents of the petitioner. My report is ready, my lord.
At the time of call, no one appears for the petitioner and no accommodation is paid. However, you are for the Gram Panchayat.
Yes, my lord. Respondent number 5. Pradhan. My lord, if the matter is passed over because it's raining outside, they believe.
However, Gadong 1 Gram Panchayat is being respondent 5 is represented by learned advocate. Stop. List the matter under the same heading on 31st July or on 1st August 2025 for further consideration. Next paragraph. However, it is made clear if on the agenda date petitioner goes unrepresented, consequential order will be filed.
Deeply obliged.
Inform your other side that it will come on Friday. But if he does not appear, matter will be dismissed 44. Yes.
Item number 6. Item number 6, my lord, I appear for the petitioner, my lord.
Yes.
My lord, the issue is, my lord, for the self-same plot, my lord, proceedings under the Highways Act, as also the proceedings under the Unauthorized Occupants Act has been drawn up. My lord, fact remains, my lord, I am occupying plot number 222. The private respondent is also occupying plot number 222. Well, my occupation is just before the first on the first line of 222, plot number 222, and he is occupying back of my portion. Well,
Under the same plot.
Under the same plot. Well, civil suits are pending. I am enjoying interim order, my lord, in the civil suits. Suddenly,
So why you have come up with this writ petition?
Suddenly, my lord, and notice under Highways Act has been issued against me, my lord, under 10(1), my lord. I moved before the Honorable High Court, my lord, on an earlier occasion, my lord. My lord will find the order at page 66. Page 66. Page 66, my lord, the High Court disposed of the writ petition, directed them to have a survey, my lord, and identify plot 215, which they allege that I am encroaching upon. My lord, thereafter, my lord, the inspection was held.
Yes.
Immediately the inspection was held. I wrote a letter to them that we have not inspected 215 as directed by the Honorable Court. You have inspected 222, plot number 222. Thereafter, my lord, a report is sent to me. The report contains, my lord, it is written enclosed sketch map, but no sketch map is supplied to me. Although there was a direction by
sketch map is to be supplied by the authority,
along with the report, my lord,
by the authorities under the Highways
Act. My lord, thereafter, my lord, what happens? The sketch map doesn't the report doesn't contain sketch map. I write to them. They keep quiet. Ultimately, hearing is done. Directed.
Who had this matter? Which authority?
The Highways Act. They were under the impression which earlier writ petition there was
the encroachment of the land. Allegation is encroachment of the land by the petitioner, which has been acquired by under the National Highways
Initially, they proceeded
1956 for construction of roads.
Initially, they proceeded under the 64 Act, Highways Act 1964. Thereafter, subsequently, now, my lord, they are in the same notice. They write, you are encroaching, we are proceeding under the 64 Act, as also under a eviction of land under the 64 Act, which is not at all, my lord, the land is not, the Act is not existent, my lord. My lord will kindly come to one page, my lord, it will clear, my lord. Well, page number 91, my lord. This is the last notice.
91.
91.
Who is appearing for National Highways Authority?
No, it's a state is appearing. It's West Bengal Highways state.
Oh.
What's the national?
Page 91.
Page 91. Page 91, my lord, it,
Just a-
from the top, my lord, it says,
All are the petitioners, addressees.
or, no, only one, my lord,
Who?
I am Suresh Mandal.
Last,
Last one,
last one, serial number Roman 10.
my lord. My lord, first they write.
Just,
notice of-
just a
my
minute. Now, what was the outcome of this notice?
But,
Whether it was hard on 4th June 2025?
no, my lord, today, my lord, at 2 p.m., my lord, hearing is fixed. Subsequently, my lord, they all,
So why before that you are coming?
But-
Let the matter be deliberated upon
But-
before the authority,
My lord,
before
my lord-
the collector.
my lord will kindly see, my lord, the first, my lord, they write notice of removal of encroachment from PWP road as per Highways Act 1964. Next, they say, my lord, the third paragraph, now therefore in exercise of the power conferred under subsection 1 of section 3 of the West Bengal Public Eviction of Unauthorized Occupants Act 1964. No such act, my lord, is there. It's not a 64 act, it's a 62 act, my lord. My lord, entirely, my lord, the two are separate things. If the land is highway, under the 64 act. If the land is, my lord, simple pathway or simple road, my lord, it will under this, it will fall under the 62 act. They say 64 act, the West Bengal Public Land Eviction of Unauthorized Occupants Act 1964. The act is not in the statute books even. And so far as the 1960
Unknown act.
and so far as the West Bengal Highways Act, my lord, they can't blow hot and cold at the same time, my lord. My lord, if and furthermore, my lord,
My query is this:
my lord,
if court proceeds on the premise
my lord,
that this is a faulty notice,
my lord.
now you can make a deliberation before the authority that this notice has got no meaning because the wrong statute has been referred to, and how this the provisions of this statute is applicable.
Well, my contention is
Now,
that
if you
my lord,
suffer an order, ultimately, then you can come.
no, my lord, there is another problem, my lord. If it's 60 order is passed under 64, 10-3, ultimately they will give notice under 10-3 to vacate, and thereafter the order of vacating, my lord. 10-3, my lord, is an appealable order under that statute. And under this statute, my lord, this statute, although doesn't exist, my lord, under the 62 statute, my lord, direct writ petition, there is no appeal forum, my lord. So, my lord, above all, my lord, taking the matter as a whole, my lord,
If it is, you are submitting, if it is a case of highway, then
Well,
it comes under the purview of 64 Act.
Well,
If it is a normal pathway or otherwise not to be termed as highway, then it will come under 62 Act for eviction of so far the land of the state government is government land is concerned or acquired land is concerned.
my lord will kindly-
Now, apparently it appears that
My lord,
this
notice is
notice
itself
was
bad.
passed under 64 Act. But there is no West Bengal Public Land Eviction of Unauthorized Occupants Act 1965.
My lord.
62.
So if it is in that event, this notice does not bear any sense.
No, my lord, this is a typographical mistake.
So no, that is typographical mistake, but a proper notice has to be done.
Notice, my lord,
Based on which this faulty notice, how a hearing is to be
my lord,
conducted,
kindly
Mr.
see,
Chaudhary.
proper notice is 17th March 2025 at page 88.
Yes, but this is the subsequent notice.
My lord, both under both the provisions we are proceeding. Under both the provisions.
But what is the meaning of this notice?
It's 88, page 88.
Page 80, page 91.
Now first look at my lord, page 88, kindly. No, she have seen her. Yeah, I will.
See, if you want to proceed on the basis of this notice at page 88,
Then kindly come page 85.
then matter can be considered. But
Kindly come
if
page
your
85.
actions
I'm
are
coming,
to be
Lord.
adjudged
I'm coming.
based on notice dated 17 March 2025 and subsequent notice dated 28 May 2025,
Lord,
then the proceeding gets vitiated.
I'll clarify. First, kindly look page 80.
My lord, may I complete my submission, my lord? Then it will-
Yes.
My lord will kindly come to my lord page 66, my lord, the order passed in the earlier writ petition. My lord, I am reading from
Just a minute. Page
68, relevant portion. My lord.
page 68.
Page 68.
Just a minute. Page 68, you are reading from page 68, yes. Accordingly,
Accordingly, the jurisdictional block land and land reforms officer, upon issuing a prior notice to the petitioner and the private respondent number 5 shall make a physical inspection of plot number 215 and shall demarcate the same in their presence and then file a report before the jurisdictional assistant engineer PWD construction. Copy of the said report shall be served upon the petitioner and the private respondent. These exercise shall be carried out and completed by the jurisdictional BLRO positively within a period of 5 weeks from the date of communication of this order. Upon receiving the report from the jurisdictional BLRO, the jurisdictional assistant engineer PWD upon issuing a notice of hearing of at least 7 days to the petitioner and the private respondent number 5 upon and after granting them an opportunity of hearing shall decide the said representation of the petitioner dated such and such to the writ petition by passing a reasoned order in accordance with. The exercise should be carried out completed by the jurisdictional assistant engineer PWD construction positively within a period of 5 weeks from the date of receiving the report from the BLRO, and the reasoned order shall be passed thereupon. My lord, now my lord will kindly come to the my
now
lord.
whether this has been done.
My lord, how this has been done, that is the question, my lord. That is the writ court, my lord, domain of the writ court, my lord, how the things have unfolded, my lord. 77, my lord, measuring of plot number such and such
No, the coordinate bench directed a jurisdictional block learning.
Coordinate bench, matlab,
Just a minute. So assistant engineer PWD, based on the report to be filed by the jurisdictional block BLRO, shall pass an order. That was the direction, sum and substance. Yes.
matlab, page 72 is the, they give a notice of inspection, matlab.
Yes.
Page 72, matlab, page 77, matlab, after the inspection is done, immediately on that day, matlab, we say that please note that although pursuant, page 77 I am reading, matlab, please note that although pursuant to the above notice dated such and such, personals from your department came today, that is 12/12/2024, but instead of measuring RS plot number 215, they measured RS plot number 222, and when the matter the High Court order was brought to the knowledge, they left the place. The entire activity has been videographed, such and such. Thereafter, matlab, they serve us a report, matlab. That is at page, matlab, 78. Report supplied, matlab, will kindly come to the last line. Enclosed sketch map of the encroachment area.
But this report was directed to be filed by the block land and uniforms officer, not by the assistant director and officer in charge Siliguri Municipal Corporation.
Matlab, that is there.
No, but how this can be done?
Matlab.
But in terms of court's order,
Matlab.
I'm asking you that BLRO was block land and uniforms officer concerned was directed to hold an inspection based on which concerned engineer shall pass an order, PW.
Matlab.
But how assistant director and officer in charge Siliguri Municipal Corporation came into the picture?
But he is told the jurisdictional BLRO part is being looked after by him. That is their subsequent case. Matlab, be that as it may, matlab, sketch
not
map,
be that as it may. When
so
the
far
court
as
passed an order
Matlab,
and
ought to
things
have
were
been done by
directed
the
to be
BLR.
done in a particular manner,
Matlab.
it has to be done in the said manner, not otherwise. So how the assistant director and officer in charge Siliguri Municipal Corporation poked his nose?
But he is told
That
by
is
the
jurisdictional
jurisdictional BLR.
alarming.
Matlab.
Why this was done, Mr. Chaudhary? Why this was done?
I let him complete, my lord. I am taking note.
No, and the simple thing is
page 86, page 86. Page 86.
I'm not hearing you, but I want an information.
We have clarified everything. Page 86. We have not done in contravention or any milord the violating the order. Page 86, lordship. Come tell me down.
Yes, page 86.
Serial number 1. Got it?
Yes, just a minute. Yes, I'm reading this.
Is the jurisdictional BLR?
So therefore, paragraph 1 is comes against you.
My lord.
You are the shop owners and it is found on the exercise carried out in terms of the order passed by the coordinate bench that you are encroaching the portion of the land.
No, my lord.
Come to page 86, paragraph
I've
1.
seen, my lord. My lord, I explain, my lord. My lord, page.
No, you at the motion stage, be precise, Mr.
No, no, my
Singh.
lord.
It's,
Page 7.
Now, what do you want at this stage?
But so far as the notice, my lord, I have shown to your lordships, my lord, at page 91, that cannot be sustained. Blowing hot and cold, my lord, under what proceedings, under what act they are proceeding, it is not clear today. And whether the land is at all under the Highways Act or under the other act, my lord,
It appears that the basis of taking steps is order dated 7th March 2025.
but 7th March, my lord,
7th March
that is
2025
also
order.
impugned in the petition.
So therefore, instead of going into
My lord.
this notice,
My lord.
now you have to assail this order.
But I have assailed this order. One of the prayers is assailing this order. But
Now,
why?
whether in this writ petition this order is assailed.
My lord. My lord. But so far as they are no.
Now, if it is
My lord, unless
It has not been assailed, kindly come to the prayer. And Millard, even if it is barred by law,
appealable order, this is a no.
it is not appealed. Well, see prayer A at page 11. Grant leave. B is notice of 6.
When is 7th March 2025? Yes. First, withdraw the order dated 7th March 2025, Mr. Chaudhary.
Millard?
First prayer is against this order.
No, Millard, it is served prayer A.
Page 20, yes.
Page 11. Our page is 11.
Page 20 of the writ petition.
Yes, Millard. Page.
Prayer A.
Millard.
Forthwith cancel, rescind, withdraw the order dated 7th March 2025.
They have annexed the previous. Sorry.
There is a first prayer.
Just page 20.
Yes.
Yes.
Come to page 20.
Yes, Millard. I have
Prayer A.
I have seen previous petition.
It has been assailed.
Yes, it is nice. It's nice.
Now, if this is the, just a minute, if this is the order
Yes, Millard.
from where it is found that
Encroachment.
RS plot number 215 has been encroached to certain extent by 10 shop owners. Now, what the steps you are contemplating?
Millard, the Highways Act, page 88.
So, if it is a misquotation, if there is misquotation of
No,
the act in your notice dated 28 May 2025.
Can you do page 88?
No. If it appears that there is no such act of the West Bengal Public Land Eviction of Unauthorized Occupants Act 1964.
Past 88 to Millard, there is a Highways Act. Can you do 88?
Yeah.
Then I'm coming. I'll answer, my lord.
In order to cut short the issue, come to page 91.
Yes, Millard.
The notice dated 28 May 2025.
Yes.
Now, subsection 1 of section 3 of the West Bengal Public Land Eviction of Unauthorized Occupants Act 1964.
It is a
There is
62.
no. Yes, it is 62.
Act
So,
is there.
so therefore, you withdraw this notice, issue a
No,
fresh
we
notice
are
and take
proceeding.
steps.
Millard, we are proceeding. We can withdraw. We can bypass. The page 88, we cannot. Page 88. Now, Millard, page 88. Millard, there is a two separate proceeding under the two separate act. One is under the Highways Act.
Now, at the same time, two parallel proceedings can continue.
But if it is, that is true. That's why I'm saying 91 I can at this moment. I can.
Last occasion, same argument was advanced by Mr. Chaudhary while dealing with the revenue matter.
91, Millard, at this juncture, Millard, can be given a little bypass. But kindly see, Millard, page 88. Page 88, Millard, kindly see an act.
According to you, there is no flaw.
Kindly see the act of 1964, Highways Act. Millard, may I hand over?
Yes.
But now, my lord, why I say, my lord, the order
Just
10, Millard. We have issued the notice under 10, subsection 1, 10 surplus 1. Millard, kindly appreciate already the hearing has already been given. Pursuant to the Honorable Court's order. And thereafter, the Honorable Court directed to take steps in accordance with law.
No, this this is the order ultimately passed in terms of the court's order.
Yes, my lord.
That is at page, that is 7 March 2025.
Page, yes, my lord, page 85.
Oh, 7 March 2025 order was after this notice dated 17th.
Yes.
No,
17th March.
the subsequent notice
No, 7th March, we have passed a reasoned order.
in terms of the order.
In terms of the order court's order. Then, my lord, we have proceeded based on the order which we have passed on 7th March. That is the proceeding of 17th March 2025.
Well, Mr. Sen, I will direct them to proceed in terms of 17th March 2025.
That's 2 minutes. Why I am saying,
Malad?
my lord, the order passed on 7th of March 2025, my lord, should not be sustained. Because my lord will kindly come to my lord, their report, my lord, page 78. Report regarding physical inspection and demarcation. I could have directed report must be given. My lord, thereafter, this is the report they hand over. Enclosed
Page.
78. Enclosed sketch map of encroachment area. I write to them, please note that the notice under reference you have stated sketch map alleged page 79, my lord. The
So
sketch
just a
map
minute,
of-
page 78, come to page 78 to the executive engineer. Assistant Director, Office of the In Charge, Siliguri Municipal Corporation is writing. It's a report which was furnished to the executive engineer PWD
There was a
in
direction-
terms of the order passed by the coordinate bench.
direction to serve upon the petitioner also. Well,
He was present.
pursuant to that direction, my lord, it was served. My lord, sketch enclosed, last line, enclosed sketch map of the
Just a minute, just
encroachment
a
area.
minute.
You have to join the inquiry. Yeah. Yes.
Now, this report was forwarded to the executive engineer, yes.
My lord, I write to them after receiving that page 78, my lord, page 79, I write to them that.
So whether this report was not supplied to you?
No, sketch map was not supplied. We subsequently gave our sketch map that is also, my lord, given in the petition that my lord will come.
Now you send a
page
letter at
84.
page 79.
79. They give me the sketch map. That is not supplied. Deliberate, my lord.
We encroach the government land and it will say the delivery. You know, I will.
Just a minute, please. No. So on 17 January, when the hearing was conducted by the assistant engineer, this sketch map was not supplied to
No,
you?
no, not at all supplied.
It is very difficult. But one by one, I'll
Take you see. Yes. Show me that the sketch map was.
no,
supplied.
first from the beginning, my lord, I will say, my lord, the order of the my lord, the past. Yeah.
Let us come back to the order passed by the coordinate bench.
My lord, 86. Sorry.
Page 68.
68. 68 relevant page. My lord, kindly mark that accordingly the jurisdictional block and land deposit officer upon issuing prior notice and the private
Mr. Chaudhary, please come to page 68, last paragraph.
that I am taking.
Yes, accordingly, yes.
Yes, that I am taking. Accordingly, the jurisdictional PLLRO upon issuing prior notice and the private respondent file shall make a physical inspection RS plot number 215 and shall demarcate the same in their presence, which we have done, demarcated in their presence. And then file a report before the jurisdictional assistant engineer PWD construction. They will file to me.
Then
Copy of the said report shall be served upon the petition of the private respondent number 5. Copy was
where copy was served? That is the grievance of the petitioner prima facie.
Well, if you
Show me that this report was served upon the petitioner. That is why it is reflected at page 79 that please note that in reference to the notice under reference, you have stated that the sketch map of valid encroachment area, however, of the said sketch map has not been annexed. Now, in view of the above, you are requested. This was this letter was issued by the petitioner to the assistant director, officer in charge, Siliguri Municipal. Show me that report was supplied to the petitioner.
Page 80 will not be here.
I want to express my satisfaction that before passing such order which was adverse to the petitioner dated 7th March 2025, that the materials including the sketch map, the report as directed by the coordinate bench was supplied to the petitioner. And to that extent, there is a specific letter issued by the petitioner addressed to the assistant director, officer in charge.
There was a really there is a enclosure. But now your lordship satisfaction whether that enclosure they have.
No, this is not it is not only my satisfaction. This was a direction by the coordinate bench.
Definitely, if there is any order, then definitely your lordship.
Yes.
In total, it should be compliant.
Yes.
In peaceful, it cannot. I am completely agree. Just keep it at 2 p.m. Keep it 2 p.m. I do not want to, your lordship may think that I am bypassing. No. I will seek that part only in instruction to substantiate that sketchment has supplied or not. If they did not supply, I will tell your lordship that it is not been supplied. We supply, that will give relevant document and so on.
Yes, in that case, come at 2 p.m.
No, this is the only grievance?
It appears. Prima facie, it appears.
No, then there is no other grievance, then it.
No, but the thing is this, on record, it appears that a sketch map was not supplied.
According to that, because we did not get an opportunity to revert. Definitely, if we do not have any file or document to substantiate it has not been supplied, I will say, my lord, it has not been supplied, and I will supply, and then my lord, the hearing will take. My lord, I am very candid.
Obtain instruction, come back at 2 p.m.
But another prayer is that, my lord, since, my lord, this entire my suit and everything, my lord, will go, my lord. I will be non-suited, my lord. An order is passed with this proceedings. Although, my lord, I am enjoying an interim. My lord, I have prayed and made a prayer in the repetition, my lord, for an appointment of a survey.
Now, I am also asking you, Mr. Chaudhary will take instruction whether it has been supplied to you.
But my instruction is
Because petitioner knows better. It is here, it is the proceeding which was initiated against the petitioner. So, in order to show your bona fide, Mr. Sen, whether it was supplied to you.
But my instruction is this: the repetition I have said. Repetition has been gone through by the advocates.
Yes, what is your instruction?
It was not served.
Yes, then what you are submitting, tell me, with regard to the interim order, you are
identification of the plot is the main thing. The moment the plot is identified, I have to vacate, my lord. My specific case is, my lord, I am staying at 222, and their specific case is that I am
now you are so far this pendency of the civil proceedings. It is too late in the day because these steps are being taken in terms of the order of the High Court.
So far as civil
these steps are being taken in terms of the order of the High Court. At that point of time, you did not raise any demand with regard to pendency of a civil proceeding.
No, that was
now
raised,
when the steps are being taken.
Now
you cannot. Now I will say that you cannot blow hot and cold.
No.
Because at that point of time, when the court directed, Justice Rai directed, then you should have taken this point. No, the jurisdictional PLRO as well as jurisdictional engineer are not authorized to do this in view of pendency of the.
No, that cannot be, because in this proceedings, in this act, civil suits are barred, that I cannot take. I can only take I have taken that point, that this report appoints, a survey past advocate or a survey past person from the panel of the High Court to identify the land. The moment it is identified, I am in or I am out. At the one stage, to a certain extent, I can say that this is my land.
That has been done. But judicial review is this, whether it has been properly done or not.
But that is one aspect of
Mr. Chaudhary is not in a position to satisfy the query of the court that this report, which was furnished by the PLR to the concerned engineer, was not divulged to you,
My,
in that event,
that is one point.
in that event, otherwise the court, the authorities are authorized to take steps in terms of the order passed in the previous process.
Well,
Mr. Chaudhary, obtain an instruction, come at 2 p.m.
Milord, and also one point, the page which attaches at page 79 say that sketchman has not been provided. But there is no whisper how the notice has been served upon.
Viral, you obtain instruction because there's a letter.
Definitely.
There's a letter
this
at page 79.
That letter is internal communication.
No. It is a letter by the petitioner at page 79.
No, page 78.
I am referring to the
Yes.
letter dated page 79.
It's definitely page
Now,
70.
now that order is going to be passed without supplying me the material,
Definitely.
that I will not permit.
No,
Obtain
no.
instruction, come back to p.m. Take back your book, place it before me at 2 p.m. Yes, next matter.
Number 7.
Lordship seek to appear for the petitioner.
Yes.
For the petitioner, my lord.
Yes.
Lordship, I will go very short. The petitioner is an elected panchayat member. Elected panchayat member. And obviously, my lord, without naming any political parties, she was sponsored by a political party. She won the elections. And the rival political party is alleged that she came and threatened her first, enticed her to join the rival political party. When she refused, she was threatened, her house was ransacked, valuable goods looted. She was even physically assaulted. Now, all this took place in somewhere in 4th or 5th of April. She lodged an written complaint before the concerned police station on 11th of April, after she could manage some courage. Till date, my lord, none of the persons, namely the FIR, has been arrested, detected by the police. So, my lord, they obtained bail. Now, my lord, what our prayer before lordship is right now, my lord, it needs the response from the state. There is no doubt about it. We want only that my lord may direct the state to file a status report as to where, what has been done and what will be done. And in the meantime, the safety of the petitioner be protected by a police. Let the state come up with a status report, my lord.
Yes. Which paragraph?
Lordship. Second page, first paragraph. Second page, first paragraph. The report has been paginated. It is at page number 8. Lordship, that part, there is an allegation that her.
Just a minute.
Lordship.
Yes, first of all, all the 6 accused persons surrendered and obtained bail.
My lord,
And then in course of investigation, IO has also served the progress of investigation to the complainant as mandated by provisions of section.
my lord, a copy of the report may be given to me. I will file my response. I will file my response.
Not required.
My lord, it is required because that is
required.
that statement is a false statement, my lord.
You obtain a report, but steps have been taken. There is
No, my lord.
Keeping this matter pin.
My lord, 1 minute, my lord. Let the report come to me. Let me see whether it is true or false.
Yes.
They say they have submitted a report. When they served a report, they must have obtained a receipt from me.
Yes, there.
We'll see to it.
Once you get page number 11.
Obedience.
Progress of investigation has been conveyed to the complainant. She had signed it. I mean,
Now, what is more important is this, that in the report, give a copy of the report, Mr. Mojumdar. Page 3, first paragraph. It is further submitted that since the case is summons trial in nature, the investigation is being conducted within the stipulated period of 6 months as mandated under section 187(9) of PNSS. The final report shall be submitted before the competent court within the prescribed time. Now, if you come to pay section 187(9).
No, my lord, that is okay, my lord.
No, please come to pay. Do you have the?
No, my lord, I don't have the.
Yes. If in any case triable by the magistrate as summons case, the investigation is not concluded within a period of 6 months from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation into the offences unless officer. So therefore, already the 6 months is not over.
Yes.
My lord, I know the.
No use of keeping
my lord,
at this stage. This is summons trial.
Right, my lord. My lord, give me 1 minute. My lord, kindly seize the photograph that is annexed with the. How
that what
my lord
will do?
When gold ornaments have been seized from looted from my house, it will be a summons tribal case.
Yes, then
that is not to be conducted.
No, my lord, let's.
Service of notice has been served upon them. They could not produce any.
My lord, at least allow me to respond to this report.
It's not required at this stage. If after 6 months it is found that there is no progress, come back.
And the threatening still continues, my lord.
Affidavit of service filed on behalf of the petitioner is taken on because next paragraph. Petitioner has come up with this writ petition, comma, inter alia, comma, questioning. Or questioning na kore alleging there is no considerable progress in the investigation in connection with PS case number 189/25 dated 11th April 2025 under section 329 within bracket 4/324 within bracket 2/303 within bracket 3 /351 within bracket 3 /115 within bracket 2 /126 within bracket 2 /3 within bracket 5 of PNS. Stop. It is also submitted by Mr. Mojumdar,
Lordship, one indulgence, my lord.
senior advocate,
Lordship, may I?
that a petitioner is an elected member of a of Gram Panchayat. Gram Panchayat member, elected
Lordship.
member, elected member of Gram Panchayat, and she member and the de facto complainant.
Yes, Lord.
Yes. And the de facto complainant whose house was ransacked
And goods were stolen.
whose house was ransacked and goods were stolen. Stop. Prayer is made for giving for providing protection to the petitioner. Next paragraph. Learned advocate representing the state respondents has filed a report dated 20 July 2025, prepared by officer in charge Sahibganj Police Station, which we have, along with necessary along with other documents, and same are taken on record. Stop. On next paragraph. On perusal of report, it appears that all FIR named accused persons surrendered before the learned court or surrendered before the court and were released on court bail, video order dated video order number video order dated 29 April 2025. Stop.
Lordship, before Lordship completes the order, may I just indicate one
Stop.
point?
It is also indicated. It is also indicated in the report.
Thank you.
That the investigating officer also served progress progress report relating to investigation to the complainant as mandated by the provisions of section 193 within bracket 3 of PNSS dated 27 June 2025. Moreover, next paragraph, moreover, in terms of section 187 within bracket 9 of PNSS if the case is found to be triable by a magistrate as summons case and investigation is not concluded within a period of 6 months from the date on which accused was arrested, comma, magistrate has been empowered to pass necessary order. However, the time fixed or however the time provided under section 187 within bracket 9, that is 6 months, to conclude investigation in connection with a summons case triable by a magistrate. However, ঠিক আছে, comma, appears to be taken note of and in the report dated 20 July 2025, it is also stated that the investigation is to be conducted within the stipulated period of 6 months. Stop. From the next paragraph, from the report, it appears that the said period of 6 months is not over, and concerned investigating agency investigating officer is directed to take steps strictly in terms of section 187 within bracket 9 of PNSS for concluding the investigation. Stop. Next paragraph. In view of aforesaid consideration, this court finds no purpose would be subserved in keeping this matter pending. Hence, the writ petition stands disposed of. However, concerned police authorities are directed to provide protection to the petitioner in order to prevent occurrence of any untoward incident as happened on urgent.
May I be permitted to place the affidavit of such?
আর একটা লাইন অ্যাড করে দেবে, copy of the report is made over to Mr. Mujumdar, non-senior advocate, representing the petition.
Affidavit of service,
Yes.
placing it on record.
Yes, affidavit service to approve.
Obliged, my lord.
6 months period is not over, let it be concluded. And they have stated in their.
My lord, our main concern was her well-being. My lord has got that.
Lordship, I am for the petitioner item number 8, Lordship. This is my affidavit of service. My lord, the petitioner is the senior most teacher of a government aided high school. And in the said school, my lord, in the said school, my lord, the office of the headmaster.
For the other side. Yes.
The office of the headmaster is lying vacant since long. So the authority of the school has decided to appoint one of its teacher to act as teacher in charge to do the administrative works of the headmaster. Now, Lordship, I have challenged the selection of the present teacher in charge of the said school.
Have you made the teacher in charge as party?
Yes, my lord.
Teacher in charge.
Yes, my
Now
lord.
the teacher in charge has joined the post.
Yes.
Yes, my lord.
Whether the approval has been granted by the DI.
Lordship.
Yes, my lord.
It has been granted.
When teacher in charge joined. Selected teacher in charge has joined, when joined?
Joining 26/4/2025. 26th April 2025, Lordship. I have challenged this for 2 reasons, Lordship.
Justice.
Lordship.
Yes, Mr. Ghosh.
She has been discharging the functions from 26th April 2025.
When the DI has granted approval.
This was confirmed, my lord, by a meeting dated 28th April 2025.
Managing committee meeting.
Managing committee.
Then when it was approved by the DI. Has it been approved, appointment?
My lord, I am told it has been approved, my lord, but I don't have the the relevant document to show, my lord, that it has been approved.
Now, on what basis you are challenging?
2 reasons, Lordship.
Challenging the
Yes.
selection.
2 reasons, Lordship. Firstly, kindly come to page number 17, my lord. This is the notification issued by my previous teacher in charge, who requested all the teachers to
Page number?
17.
Yes.
It shows, my lord, this notification is of 26th April 2025. And it shows that all the teachers who are willing to join in the said post to submit their academic qualification within 1 p.m. on the very date, on the said date, Lordship. So for 2 hours notification was issued. Just for 2 hours notification, this selection was conducted, Lordship. This is the first thing, Lordship.
But in the case of teacher in charge, there is no selection process.
No,
Because
Lordship.
it's not an appointment, it's an engagement.
Lordship.
Now, is it your case that you are senior to the petitioner?
Yes. I am senior to that lady, Lordship. And at this juncture, Lordship, I am placing reliance.
Who is appearing for the school authority?
Though I am representing the teacher in charge, my lord, I have all the relevant documents. So, my lord, which your
But
lordship
you
might
cannot,
require.
your appointment is being questioned, being
Yes.
junior to the petitioner.
Yes,
Now,
my lord.
the managing committee should be represented before this court that on
My
what
lord, I am
was the
not-
consideration
I am
for
not holding
selecting the,
wakalatnama.
selecting the respondent number 9.
Yes, my lord, I'll just.
Ignoring the seniority of others.
Yes, my lord, my lord.
So therefore, that reply I will not hear from you.
My lord, because.
The school has to satisfy this court.
My lord,
Who is appearing for the school authority?
my lord, I am not holding the wakalatnama for the school authority. The
So
managing
therefore,
committee.
therefore, let a notice be served upon the
I have
school
already
authority.
served, Lordship,
Should I,
against.
my lord, just indicate one thing, my lord? My lord knows that this is not only seniority, it is merit cum seniority. And the person who has been appointed, and it has to equivalent qualifications as that of a headmaster. Your lordship knows this. Now, my lord, the petitioner herein, although he is a senior candidate, but he neither holds a master degree nor a B.Ed. That's why this person was appointed, my client was appointed, who holds a master degree and holds a qualification of B.Ed, which is requisite for this post. And my lord would recall Justice Dipankar Datta's judgment, which I discussed this in detail long back. I am carrying that judgment also. So prima facie, this at his instance, this petition is not maintainable at all. Because there is no infirmity in the appointment. The person who has been appointed holds the requisite qualifications at par with a headmaster, which he does not.
Show me any provisions.
No specific rule is there, Lordship.
It is
Regarding-
there. It is
regarding
there.
engagement
Justice Doctor's
Judgment
judgment.
will come later.
There
Show
is a
me-
notification.
Show me, yes, show me.
There is a notification.
আমাকে একটা copy।
Millard kindly takes this in 2013. Millard, if I may just hand this up. Millard, the School Service Commission's notification is referred to. Next page, Millard, is a typed copy of the notification. This same notification was relied upon by Justice Dr.
So petitioner does not have the requisite qualification to become headmaster.
To become headmaster.
He is not holding postgraduate degree.
No, not B.Ed. And will Justice Dotto's judgment, the qualifications that a teacher aspiring for appointment as assistant headmaster ought to possess are akin to the qualifications to be possessed by a teacher aspiring to be appointed as headmaster.
এই দাও
আমাকে একটা কপি দেন দুটোই আছে আমি দিয়ে দিচ্ছি
কেস নাম্বারটা ডাউনলোড করে নিচ্ছি
WPA 37,302 Millard would take paragraph 8, the last portion. Millard would find the 1991 notification, which I placed before your lordship, is also quoted in the next page.
3rd August 1991 notice.
That's right. Is the one who has requisite qualifications. I am sorry.
But paragraph 8, last part, it says that the qualification that a teacher aspiring for appointment of assistant headmaster ought to possess are akin to the qualification to be possessed by teacher aspiring to be appointed as headmaster. So therefore, the qualification of assistant headmaster was being considered.
And
I'm not the
teacher
teacher
in
in
charge.
charge.
Millard kindly goes to the next page in the judgment. Fifth line from the top. In the absence of a regular headmaster, headmistress, that entire line, Millard, I am placing reliance upon. Only seniority has been deprecated. Millard would kindly appreciate that in the judgment.
Yes, if you do not have the qualification, then you are hit by this ratio of.
Now, my lord,
Supra.
my lord, one more thing, my lord, I'll just add. My lord, this petitioner, being the teacher representative, was part of the managing committee. On the date of the meeting, he himself has proposed the name and has acceded to her appointment. Kindly see, my lord, this is not absolutely an afterthought and motivated by ulterior motives. See, the name of the my client is there. He has approved her appointment, being a member of the managing committee. Arjun Vishwakarma.
I need to seek instruction in this regard whether he has.
No,
And my lord, one thing, kindly come to page number
you
25.
have the requisite qualification to become headmaster.
Lordship,
Are you possessing master degree?
I need to seek instruction, Lordship, but in this regard, Lordship,
Then
kindly,
instruction come back. No
Lordship.
further adjournment.
kindly come to page number 25 of
I
my
have
writ
already
petition.
heard this matter last time.
Kindly come to page number 25, Lordship, of my writ petition. From the West Bengal Board of Secondary.
Coming there. In the meantime, you will get 10 minutes time, obtain instruction and come back.
Obliged, Lordship.
Yes, what is your instruction?
My lord, he doesn't have master degree. It's genuinely admitted.
Then therefore you are here. Your case cannot be considered in view of the law laid down in Rina Rai Supra.
Lordship,
Where
one
it
thing.
has been come to give a copy.
I
of
have,
this order.
yes, he has given me, Lordship. Kindly come to page number 25 of my application once, Lordship.
Come to paragraph 8 of this judgment. Where it says that there is nothing wrong in appointing the senior most or any other willing teacher having requisite qualification and experience for appointment on the post of headmaster, headmistress as the teacher in charge of the school on condition that she would have to revert to his or parent post of assistant teacher as and when regular headmaster, headmistress.
Yes.
So if you do not have the qualification of postgraduate degree, your case cannot be considered, especially when there is a teacher having qualification.
Now, Lordship, one thing, just one thing consider, Lordship. Kindly come to page number 25 of my application, Lordship. It has been clearly mentioned by the West Bengal Board of Secondary Education by a reply of under Right to Information Act that no such qualification is necessary to be appointed as TIC.
But court has passed an
Yes.
order. High Court
Now,
has decided.
now the coordinate benches of this court, Lordship, says that the senior most teacher, kindly come to page number 30.
And you have given that in the said meeting, I so and so member of the managing committee of so and so school propose and support Montulama.
No, Montulama has not been appointed as TIC.
For the post of teacher in charge.
But she has not.
She is the present teacher in charge.
Not no Montulama, a lady.
No, but the petitioner has in the meeting has given no objection in favor of one Montulama.
But Montulama is not the TIC of that school.
Support of Srimati.
No, she is my client.
Montulama na, tomar client.
Momotalama.
Momotalama.
So therefore, it has been given already.
Any other person's name he may be given his consent. Another thing, Lordship, kindly come to page number 30. This is an
Sorry. Yes. Matter is heard in present. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next file.
But whether signature was obtained by force or not, Lordship, that has to be ascertained first, Lordship.
Who is the respondent? Your which respondent is your client? Seven.
Yes.
And who is 9? Teacher in
Previous, yes, Lordship.
Teacher in charge.
On behalf of the petition. Stop. Next file. It's a feud in between the petitioner and respondent number 7 for being appointed as teacher in charge of Ila Palchoudhury Memorial within bracket tribal close bracket Hindi High School, Darjeeling, within bracket hereinafter referred to as state school. Stop. It is contended on behalf of the petitioner that he is senior to one Momota Lama being respondent number 7 in terms of their respective, in consideration of their respective dates of appointment. Therefore, petitioner ought to have been engaged as teacher in charge of the said school by giving credence to petitioner's seniority. Stop. Ignoring seniority of the petitioner, respondent number 7 has been selected, or respondent number 7 was selected and joined the post of teacher in charge on 26th April 2025, which is assailed in this petition. Next paragraph. It is contended and it is also submitted that seniority should be given priority in selecting the candidate for the post of teacher in charge, which has not been done, which was not done in the first place. Next slide. On the contrary, learned advocate representing respondent number 7 submits that respondent number 7 is having postgraduate qualification and B.Ed, which is a requisite qualification for appointment of headmaster / headmistress in a government aided high school.
10 years continuous experience. If your lordship wishes to record
Stop.
that.
It is also submitted that the respondent number 13 is respondent number 13 before her selection.
7.
Respondent number 7 before her selection completed 10 years of approved service. Stop. According to respondent number 7, educational qualification as well as length of approved service made her eligible to be selected for the post of teacher in charge in the said school, whereas respondent number, whereas petitioner does not have or does not possess a requisite qualification, that is postgraduate degree. So in support of such submission, reliance is placed on the order of Honorable Justice Dipankar Datta, or judgment of Honorable Justice Dipankar Datta dated 17th February 2015, passed on WPS 37202 of 2013 within bracket Srimati Veena Rai versus State of West Bengal. Stop. The reliance is also placed on a notification dated 3rd August 1991, being number EDN, E capital DN small, full stop, within bracket capital B / capital I capital M hyphen 25/9. Which provides that for appointing a candidate as teacher in charge of a secondary or higher secondary school in absence of headmaster, qualified assistant teacher should be interpreted as one who has the requisite qualification and experience for appointment as headmaster of secondary / higher secondary school. Stop. Next paragraph. In addition thereto, it is brought to the notice of this court that in the managing committee meeting conducted on 28 April 2025, respondent, petitioner did not raise any objection or did not raise objection against selection of petitioner for being appointed as teacher in charge. A teacher in charge, and in support of same, a document is placed before this court and same is taken on. Next one. State respondents are, who is for the state? For the state respondents are also represented by learned. While examining inter se merit of the petitioner and respondent number 7 for being adjudged as an eligible candidate to be appointed as teacher in charge. It appears, apart from seniority, merit is a relevant consideration which ought to be given precedence or preference, which ought to be given preference over respective seniority. In consideration of the ratio decided in Rina Rai Sutra. Stop. It is decided by the coordinate bench that there is nothing wrong in appointing the senior most or any other willing teacher having requisite qualifications and experience for appointment on the post of headmaster/headmistress comma, as the teacher in charge of the school on condition that he/she would have to revert to his/her parent post of assistant teacher as and when regular headmaster/headmistress is selected, comma, appointed and takes charge. It is also found in the notification dated 3rd August 1991. It was provided that for the purpose of appointment as teacher in charge of a secondary or higher secondary school in the absence of headmaster, comma, the qualified assistant teacher should be interpreted as one who has the requisite qualifications and experience for appointment as headmaster of the secondary and/or the higher secondary school. Stop. Next one. On conjoint reading of the judgment dated 17th February 2015 and the notification dated 3rd August 1991. What is found to be relevant for filling up for appointment of teacher in charge in secondary/higher secondary school is educational qualification of the teacher concerned, which makes that teacher eligible to be appointed as headmaster/headmistress in secondary/higher secondary school. In the present case at my hand, indisputably, petitioner does not have postgraduate degree, which is essential qualification for being appointed as headmaster/headmistress. On the contrary, respondent number 7 is possessing requisite qualification to be appointed as headmaster/headmistress, having possessing postgraduate degree and B.Ed.
Not one indulgence, my lord.
Next one. Before parting with it, it needs to be recorded from a document which is filed on behalf of respondent number 7 that in the meeting dated 28 April 2025, petitioner did not make a demur against selection of respondent number 7 for the post of teacher in charge. But subsequently, such engagement made in favor of the or made in favor of respondent number 7 is questioned by instituting this writ petition, which ought not to be encouraged. Next slide. In view of aforesaid scenario, no relief can be granted to the petitioner. Writ petition stands dismissed. Urging xerox certificate.
My lord, one indulgence, lordship. I have given wrongful information under Right to Information Act by the board itself, lordship. That has been
that is not relevant in view
lordship.
of the broader perspective.
Lordship.
Decided that is not.
Can I take back the documents, or will I retain it with the records?
No, it will be written with record. I have recorded it.
Obliged, lord.
Well, I am for the petition is item number 9, madam. Well, the petitioner is a lady, my lord, who was carrying on business, my lord, and the business was totally operated by her husband, my lord. And subsequently, my lord, they were having certain problem, my lord, issues with them, my lord. The family, there was a family settlement between the two parties, my lord, the husband and the wife, my lord. And the wife has separated. She's staying in Jalpaiguri along with the two children, my lord, and the husband is now staying in Siliguri, my lord. During this period of time, my lord, noted, my lord, it was operated by the husband, my lord. This whole company was operated by the husband, my lord. Although the lady was the proprietor, my lord, the petitioner was the proprietor, my lord. Hereinafter, my lord. Yes, my lord. Should we continue, my lord?
Yes.
My lord.
Yes.
My lord, hereinafter, my lord, on separation, my lord, the company, my lord, as because the company cannot be changed, my lord, under the GST law, my lord, being a proprietor, my lord. It has to be cancelled, or my lord, a surrender letter has to be forwarded to them. This company came to the with the proprietor, the petitioner itself, and upon certain thereafter, going through the document, it was seen that there was an appeal which ought to have been filed, and the anomalies were two, the merit of the appeal, were two, whereof, as per the provision of section
Appeal was
70,
filed for what? Appeal was filed for what?
for there was a certain claim, in the year, it is appeal period is 1819, the merit of the appeal, it is for the period 1819, in the period 1718.
For the period, which period?
1819, appeal is
2018-19.
Yes, 2018-19.
2018-2019, there was certain claim.
No, 1718 there was certain claim which was availed in 1819.
Yes.
1819, the notice was that I have availed excess input tax credit.
You have availed excess
input tax credit.
Tax credit.
As because 1718, I can avail it in the subsequent year up to September return filing. As per section 16(4). The appeal was barred by limitation. Admittedly, it was barred by limitation as because the people who were operating this company,
this is the appeal under section 100 under
107. 107(1), and the appeal order is in page number, if your lordship comes down to page number 53, from the bottom, one paragraph.
Just a minute. Page 53, last paragraph.
Last but one paragraph,
Yes.
Last bit. It is clear from the above that the appeal has been submitted within 3 months from the date of communication of the order appealed against, and the appellate authority may condone the delay for further period of 1 month if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal. Hence, the maximum time limit allowed within which an appeal has to be filed is 4 months. But taking this connotation, it was passed that the appeal was filed by delay, but the circumstances, presently the lady is staying separated. There is no divorce, as yet, there is no divorce, but there is a family settlement.
When the appeal was filed, when it was required to be filed, and what was the delay?
Delay was 364 days,
394.
After deducting that additional.
What was the last date for preferring an appeal? Preferring this appeal?
Last date for preferring an appeal, I'm just a minute, order was 16/1/2024. Order was 16/1/2024.
Then after
4 months
plus 30 days.
4 months,
120 days, right?
16/5/2024.
16/5/2024 was the last date. And when the appeal was filed?
Page number 37 on 15/5/2025.
15/5/2025.
Page number 37.
What is the explanation?
Explanation, in detail, just a moment.
There is a separation in between the husband and wife, not formal
page number
separation,
48,
but they are staying separately.
They are staying separately, This is, normally it happens,
You know very well, section 107, subsection 4, where no limitation act, section 5 of limitation act does not apply. So therefore, court is a court of equity. Court in certain cases finding that there are explanations in support of delay, and considering the length of delay, sometimes court is condoning such delay. It is not coming under under that category, Mr. Choraria.
My lord, kindly have.
Because if you go
she's a lady. She's a lady, my lord.
There are catena of judgments by the Supreme Court that if the time is fixed in the statute, that cannot be extended, where ex facie there is no application of limitation act.
My lord. My lord, I didn't get you.
Let us come to section 107, subsection 4.
Well, let us, well, first of all, well, let us come to the condonation petition, my lord. Once, my lord, let me lay down the case, my lord. Well, the condonation detail has been given, my lord.
Now, if the wife is staying at Jalpaiguri and husband is staying in
Yes,
Siliguri,
separated, my lord.
how does it have an impact in the matter of preferring an appeal?
My lord, it has, my lord. My lord, being a
How?
my lord, previously, my lord, as because it was operated by her husband, my lord. The wife's husband was operating this company, my lord. No information was coming to the wife, my lord. But it happens. It is the normal thing. But subsequent to the separation, my lord, as because this was owned by in the name of his wife, my lord. Now the transfer of the company has also gone to the wife, my lord. And after the transfer, she comes to know that there is a appeal which is pending, my lord, to be filed.
What is your instruction?
Why not? They did not submit any documents to the court that there is a separation between the husband and wife.
My lord, it is a mutual separation, my lord. But it is
Firstly, my lord, and secondly, there is a delay of 394 days, my lord. And most importantly, my lord, they were filing returns, my lord. That separation did not debar them from filing the returns, my lord. Why the separation debarred them from filing their?
My lord, was the wife? My lord, the wife was not having the control of the business, my lord. My lord, admittedly, wife was
when
not
the return was filed. Why appeal was not filed within time, Mr. Churali?
My lord, appeal was not within the time, my lord, as because the
in the matter of filing appeal, there was delay. In the matter of filing returns for getting the benefit of input tax credit, no, there was no delay.
My lord, it is to be explained by the husband, my lord, how the wife can be penalized for this. My lord, and moreover, my lord, your lordship comes down to, my lord, page number, my lord.
Any input tax credit.
My lord. My lord, lordship, it comes down to, my lord, page number 20. My lord, lordship comes down to page number 25, my lord. My lord, there is a merit, my lord, in this case, my lord. Page number 25, my lord. Lordship, come, my lord. My lord, page number 25, my lord. No person, my lord.
Issue.
My lord, page number 25, my lord. Once my lord, lordship comes down, my lord.
Matter is affidavit of service filed.
Page number 25, my lord. Once, my lord. My lord, principle of natural justice is being hit, my lord, in this case.
Stop. That is not a ground for condonation of delay.
My lord, but if I do not get any opportunity of hearing, my lord.
That is not a
in that
ground.
case, my lord,
you are not heard before here passing this order.
yes, my lord. Yes, my lord. My lord, 25 lordship comes, my lord.
Page 25.
25.
Yes, page 25.
Malad, there is a box, Malad, description, serial number, description, particular, Malad. In the bottom, Malad. Malad, here the date of personal hearing is NA. Whereof section 75(4) categorically says a personal hearing has to be afforded.
That is on merit.
My lord.
That is on merit.
No, my lord. My lord, 75(4) categorically says that wherever an adverse order is contemplated to be passed against the petitioner, in that case, a personal hearing has to be provided. And there is a division bench judgment of this court, my lord.
But when the issue was considered in terms of section 107, subsection 4, whether this delay is to be condoned or not, you are not heard.
My lord, in that case, I was heard. In that case, my lord, but the root of the matter, my lord, the natural justice goes to the root of the matter, my lord.
My lord, yeah, fine. But in page number 24, it is a summary of show cause notice. Now, over here.
Yes, show cause notice, my lord, comes to 75(4).
Yes.
Date of personal hearing, he says that has not been given. Any, not applicable stated. Now, my lord, if your lordship goes to page number 26, it's a detailed show cause notice. And in page number 28, detailed show cause notice. 26. And in page number 28, he has been given the time, the date, everything with necessary documents he was supposed to appear.
So show cause was replied.
The show cause was replied. Yes, but he was given the opportunity of hearing personal hearing, my lord. It is detailed. It is clearly stated 15/1/24 at 12:30 p.m. with necessary documents. He's supposed to appear. Paragraph, page number 28. Was given the opportunity. It's not so that he was not given the opportunity of personal hearing. And he submitted those documents. He was given the opportunity.
So 15 January 2024 was the date fixed for appearance of the petitioner.
At 12.
Well, 15 January was the date fixed for filing of the reply.
Same thing. We're giving the opportunity of personal hearing. Could have come before the department, submit those paper, the personal hearing. Not so that it was not given.
Now, whether you appeared on 15 January 2024.
No, how do I appear? My lord, how do I come to know, my lord? Lordship comes down to page number 24, 25, my lord. Has the date been mentioned over here? But 25, my lord, page number 25. My lord, he is stating the date by which reply has to be submitted is 15/1/2024. The date of personal hearing
is page 25. Date on which reply is to be submitted 15 January 2024.
15 January 2024.
Yes.
Thereafter, next line, my lord. Date of personal hearing. How do I come to know, my lord? It is NA. Where is the date which has been mentioned at 15/1? My lord, whatever has been shown, my lord, in 28.
The notice was not given to the petitioner to appear on.
How do I appear?
How the petitioner get the information that he is required to appear or she is required to appear before the appellate authority for consideration?
Well, the detailed show cause notice shows clearly in page number 28.
No, but the notice is 25.
Yes, ma'am.
What is the date of this document which is at page 28?
28, my lord.
Yes.
14/12/2023. Now it's So it's
14/12/2023.
yes.
Just one day before.
14/12/2023.
Yes, come to page 26, 14/12/2026, 2023.
Yes, my
And where the last page, page 28, saying that in the light of so and so,
15/1/2024.
to appear before the undersigned 15 January
2024.
But 2024, yes,
Yes.
15 January 2024. And order was passed on 16 January 2024.
2024.
Yes. So on 15 January 2024, this notice was given on 14 December 2024.
2023.
2023. Yes. Come to page 26.
My lord, page number 26, my lord.
Yes.
My lord.
Page 26. This is this is this is the document dated 14 December 2023.
My lord.
And where tax and page 28, come to page 28. To appear before the undersigned on 15 January 2024.
My lord, a notice ought to have been issued upon me intimating that I will have to appear on 15 January 2024.
So what is this, page 26?
My lord, page 26, the date on which, my lord, the date on which the order has to be passed.
What is the purpose of issuing this document, page 26?
Well, they have to appear before the authority and give a show cause why the ITC was availed in excess, my lord. But they
My lord, purpose, then what is the purpose of, my lord, page number 24? The notice.
Yes, Hamari show cause notice is dated 14 December 2023.
My lord.
In addition, there to page 26 is a detailed show cause.
My lord.
Which is dated 14 December, also dated 14 December 2023.
My lord.
Then come to page 28 to appear on 15 January 2024.
My lord, but the summary, my lord, the page number 24, my lord, it is a notice. Notice is not having any date. The notice, my lord,
this is what? To appear before the undersigned on 15 January 2024.
My lord, in the fiscal statute, my lord, the notice has to be properly filled up.
So you are on this this formality relating to page 24 that it was not properly filled up.
My lord, 25.
But it goes into but it pales into insignificance in view of subsequent show cause notice dated 14 December 2023. You are correct. You are correct that the table was not filled up. Only the date by which reply has to be submitted is 15 2024. Now, Mr. Choradia, if you proceed on the basis that you are under the impression that only 15 January 2024 was the date fixed for filing of reply, that appears to be incorrect submissions in view of the subsequent show cause notice dated 14 December 2023. And where page 28 it is stated that to appear before the undersigned on 15 January 2024.
Malad, but the notice was not properly filled up. And Malad, section 75, 75.4, Malad, Lordship 1 goes to 75.4, Malad. Malad, the provision has to be gone through, Malad, 75.4, Malad.
Is taken on record. Next paragraph. Precisely, case has been attempted to be made out for condonation of delay of 394 days in preferring appeal under section 107 of West Bengal Goods and Services Tax Act 2017. Stop. Stop. Where is the order? Where is the order which was under appeal?
Malad, the order under appeal is page number 33, Malad.
33.
33.
53.
The order which is for appeal, under appeal. 33 then, madam. 33, madam, 33. It was challenged in appeal. 33 is the order which has challenged them.
More than 15 the reply, he has not considered the reply. 16 is passing of the reply.
to answer it. And where is the order of the appellate authority?
My lord, 53.
Adjudicating authority passed an according to the petitioner, adjudicating authority passed an order on 16 January 2024. And on being dissatisfied with such order, an appeal was preferred on 15th May 2025. Whereas in terms of section 106, 107, of the said act of 2017 over said act of 2017, last date for filing an appeal was 16th May 2024. Stop. Therefore, there was a delay. Therefore, there was delay of 394 days. Stop. In support of prayer for condonation of delay in entertaining the appeal preferred by the petitioner, it is submitted by the learned advocate.
Well, explanation submission is in paragraph number 7 and 8.
Husband and wife is the writ petitioner.
My lord, paragraph number 7 and 8, my lord.
There was marital discord resulting in informal separation between them, which compelled the petitioner to stay at Jalpaiguri, whereas husband of the petitioner was staying at Shiliguri. Stop. Petitioner.
Paragraph number 8, my lord.
The petitioner could not take steps within time to prefer appeal since the company was run by the husband, though proprietor was the petitioner. Though proprietor was the petitioner. Stop. Next paragraph. It is also submitted that there was violation of natural justice based on a document at page 25 of the writ petition, which is part of summary show cause notice. It's a summary show cause notice, which is part of summary show cause notice, wherein date was fixed for submitting reply on 15 January 2024, but no date of personal hearing was fixed, which prevented the petitioner to appear before the appellate authority or appear before the adjudicating authority. Appear before the adjudicating authority. Before the adjudicating authority, petitioner appeared.
No,
Did
they
not
did
appear.
not appear.
But before the appellate authority,
They
petitioner
appeared.
represented. হ্যাঁ, কি বলছেন? Stop. Next one. Now, ওর সঙ্গে stop. Therefore, according to the petitioner, order of the adjudicating authority dated 16 January 2024 was passed without granting opportunity of hearing to her. Next slide. West Bengal, state GST authority is represented by learned advocate who has opposed the prayer of the petitioner. By making submission that delay is 394 days, which may not be condoned, since in terms of section 107 within bracket 4, grace period is 30 days, not beyond that. Stop. It is also submitted that there was no formal separation in between the petitioner and her husband, and petitioner and returns were filed during the returns were filed at the material point of time. Therefore, it may not be concluded that petitioner was prevented by sufficient cause from preferring appeal within the time prescribed under section 107. Stop. In support of in order to buttress the stand of the authority, in consideration of the point taken relating to violation of natural justice by issuing summary so cause notice dated 14 December 2013, not fixing a date of hearing. Notice of this court has been drawn to a subsequent show cause notice. It's
a detailed show cause notice.
Of this court has been drawn to a detailed show cause notice dated 14 December 2023, wherein petitioner was duly informed to appear.
It is an annexure to the show cause notice, my lord. It is an annexure to the show cause notice.
That is the detailed show cause notice, which is
on the top, my lord, in page number 26.
Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties, court is considering validity of the order dated 16 January 2024 passed by the appellate authority, not the order passed by the adjudicating authority What is the order of the adjudicating authority?
It's in page number 33, adjudicating authority, and appellate authority is in 53.
I said we can court is considering court is considering court is considering the order dated 27th May 2025 passed by the appellate authority, not the order dated 16 January 2024 passed by the adjudicating authority. Stop. Next paragraph. It is submitted on it is contended on behalf of the petitioner that due to informal separation in between the petitioner and her husband, compelling the petitioner to stay separately, was the main reason for causing delay in preferring appeal.
Main reason page number paragraph number 8 has been elaborately stated.
Stop. But it needs to be taken into consideration that at a relevant point of time, returns were filed. Therefore, it ought not to be inferred that an assessee who was filing returns in time could not prefer appeal under section 107 within the time prescribed therein.
It was a husband who has done this.
Order of the appellate authority, appellate authority passed order on 27th. Adjudicating authority passed order on 16th. On page 33. On 16 January 2024, whereas appeal was filed on 15th May 2025, causing 394 days delay, which in absence of cogent reasons, this court finds ought not to be interfered with. Which in absence of cogent delay ought not to be considered in view of the taking note of the order passed by the appellate authority on 27th May 2025. Order of the appellate authority dated 27th May 2025. Stop. Section 107 within bracket 4 prescribes if appeal is not presented within the regular period of 90 days, in that event, on expressing satisfaction, appellate authority can condone the delay to the extent of 1 month and not beyond that. When statute has prescribed condonation of delay in entertaining appeal to the extent of 1 month, in absence of cogent reasons for condoning such delay, comma, delay of 394 days should not be condoned. Which would render the provisions under section 107 within bracket 4 OSU. Moreover, it is not brought to the notice of this court on behalf of the petitioner that Limitation Act, that section 5 of Limitation Act applies in dealing with appeal preferred under section 107.
My lord, it applies, my lord. This is the judgment of this court, my lord.
It applies.
My lord. SK Chakraborty, my lord. SK Chakraborty division bench judgment, my lord. Whereof, my lord, lordship has held, my lord.
But in the statute,
My lord, the SK Chakraborty statute.
It is not there, but by the law laid down by the court.
That is pending with the Supreme Court.
My lord, it is not the law, my lord. Pending does not.
Yes, that part is struck off.
My lord, great.
Next paragraph. What is important in the present case is the reasons assigned in support of condonation of delay is found not to be appropriate reasons. Stop. Next paragraph. Attempt is made on behalf of the petitioner to question is 33. Order of the adjudicating authority dated 16 January 2024 on the ground of violation of natural justice. Since date of hearing was not duly notified. Stop. Such submission made on behalf of the petitioner pales into insignificance. In view of detailed show cause notice dated 14 December 2023, wherein petitioner was directed to appear before the adjudicating authority on 15 January 2024. But the petitioner did not appear. Stop. Next paragraph. In view of aforesaid considerations, no relief can be granted to the petitioner. Stop. Petition stands dismissed. Urgent xerox.
Grateful, lordship.
Next.
I'm for the estimate.
Issue. You are for the respondent.
Yes, but it's a respondent.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocate. Next paragraph. Video order dated 21st July 2025, acceding the prayer made on behalf of the petitioner seeking accommodation or accepting the prayer made on behalf of the petitioner for accommodation. Matter was fixed for consideration today, 28 July 2025. Stop. Next paragraph. It appears petitioner has lost interest. Stop. Writ petition stands dismissed for default. Parties to act on the server. Next.
Lordship, in this item, I'm paying for a day's accommodation, Your Lordship. Learned senior is indisposed with health issues, Your Lordship.
At the time of call, accommodation is paid for on behalf of the petitioner. Stop. State CGST authority. State CGST authority is represented. State authorities are represented by learned advocate. Advocates. Next paragraph. This the matter before the next available circuit, subject to convenience of the bench.
আচ্ছা আমারও মামলা এলো টিফিনও শুরু হয়ে গেল যন্ত্রণা আসলে এই ঘর ঢোকাটা খুব অসুবিধা তো আসুন আসুন বলুন দেরি আছে তো 1:45-র সময় আসুন ওপর তো লক করা আচ্ছা বসুন বসুন
Call the passover matter.
Six hundred I prefer the petitioner. They were to take instruction, state.
Yes. But the notice was served.
Only the sketch map is required to, entire report needs to be.
As you are prayed for by or by letter at page 79.
Right.
They are on the way, my lord, but what I have learned, that has not been supplied. But let them come, my lord, let me have a look, my lord, kindly, because they're on the way. What is the instruction is that they haven't. But my another instruction is required why the two proceedings are, they have initiated. That is also required, my lord. Fairly, that is my lord, my even for my knowledge.
230.
I hope so, my lord. The moment, if it is before that, my lord, I will
230. Next. 12.
My lord, I'm appearing on behalf of the petitioner. My lord, my learned senior Mr. Bodhayan Bhattacharya was to lead this matter today. However, he's ill, he's indisposed. My lord, I will be addressing your lordship to the best of my ability in this matter. So, my lord, this matter is this matter.
Who is ill?
Pardon me.
Who is your senior? Who is ill?
Mr. Bodhayan Bhattacharya, my lord. May I place, my lord?
Who is for the, you are for the state?
My lord, the notification, MS Central is also a party.
Who is the appearing for the central?
Challenge the notification.
Who is appearing for say CGST?
Today, though, but generally, my lord, Mr. Majumdar, he appears.
Nobody is for the central
Or
GST.
Mr. Agarwal, either.
My lord.
Mr. Agarwal appears. Very well, not today. It will be on Wednesday.
But the affidavit is, because notification has been challenged. Unless the affidavit has been used.
Well, CGST is not represented. You do one thing, inform the learned advocate representing the CGST authority. I'm fixing the matter on Thursday.
Wednesday.
Grateful, my
Wednesday.
Why Thursday you have difficulty?
I am thinking to visit the Apollo, subject to the, let's see the.
Well, Wednesday. Very well on Wednesday. 28, 29, 30th.
My lord, it may retain the same position in the list.
Yes.
Grateful, my lord.
If it will not upgrade, same.
30th.
Grateful.
My lord, item number 13 is also the same matter where the virus of the notifications are challenged.
Same adjourned till 30th July. Today I am not passing any order.
Same issue. Same.
Grateful, my lord.
May I please your lordship? Lordship, in item number 14, I am appearing for the petitioner.
Yes.
Lordship, in this matter, Lordship, before going to the notice which is served upon the petitioner for their eviction by the Devotar Trust Coachbihar, I'm telling some facts to your lordship.
Nobody is appearing for the respondents.
Oh, lordship, I have served an affidavit of service also
Show me the
ready.
affidavit service. Where is affidavit service?
Lordship, my fellow junior, Mr. Mitro, was there. I told him to.
Nobody is there. This matter was taken up on 21st July 2025.
Yes.
Then it was adjourned. Then today nobody is appearing. First of all, state respondents are not represented. Second,
Lordship,
no affidavit of service. How the court can proceed?
No, lordship, perhaps my junior not in court, but the clerk handing over the copy to one learned advocate.
At the time of call, no one appears for the petitioner, and no one appears for the respondents, and no one appears for the respondents. Stop. Today also, stop. Today, no affidavit of service is filed on behalf of the state on behalf
Lordship,
of the
Lordship, the affidavit of service is filed by my fellow brother. He is requested to file it. He is requested to
for the
file.
other side.
I have to check your lordship. I have not attached the matter. I'm just.
Director of Land Records, State of West Bengal, in all matter state is represented. Why in this matter state is not represented? How you have served?
Lordship, upon the district magistrate being the chairman of the
Show me that you have served notice upon the additional government leader or not?
additional government leader also sent through email, lordship.
Yes, yes.
No, email will not do. You have to serve hard copy. Why you have not served it? Matter was taken up on 21st July.
Your
Today we
lordship,
are
I'm not
20th
attached to the
July.
matter. Just now they given to me that affidavit of service. Just nobody is appearing that I just.
You are not appearing in this matter.
No, I just.
No,
So then
he's
why
not
you
appearing.
are coming with an affidavit of service? What sort of practice is this?
Your lordship, because he.
You don't appear if you are not in a position to file your affidavit of service on behalf of the petitioner. Please don't appear.
Okay.
In one matter, Mr. Chaudhary, in one matter, in the last week, I passed an order granting liberty to the learned advocate to amend the cost title and add one party. Then, in course of this day, nobody was there to amend it. Then my officer contacted the advocate who appeared along with the learned advocate who appeared online. Then my officer was informed that that advocate was hired for a day. So therefore, he is not in a position to amend the cost title, and nobody amended it. So if you are not in a position to file affidavit of service, please don't appear.
Who is the AOR? AOR, who is the AOR?
Why you are coming?
AOR is responsible in all aspects. Who is
This
AOR?
is happening here.
No, who is AOR? Tell me. Who is AOR? Advocate on record.
He's an advocate on record.
Mr.
Lordship,
Dhar is Mr. Dhar, you are an advocate? I don't think so.
Lordship,
Who is the advocate on record, Mr. Dhar?
Mr. Ankon Mitra.
Sorry, Ankon Mitra.
He was in court early in the morning. He was in court, but subsequently, due to his
Please don't appear
personal
in this
problem, he
matter.
left the
It
court.
creates
Lordship.
complication.
Yes, yes.
You take your
My apology, your lordship.
No, it is not. It invites the bar council even thereafter, if any consequences are there.
My officer was told that he was hired for a day. So therefore, he will not amend the cost title.
Lordship, on Thursday, Lordship, in the meantime, again,
Sorry,
the
it's
father.
not possible. Sir? Stop. Next paragraph. Since the learned advocate representing the petitioner appears on virtual mode, sentence table bolo na thik kori. Since on behalf of the petitioner, since learned advocate representing the petitioner appears on virtual mode. Stop. Next paragraph. Hearing of this writ petition stands adjourned. List the matter before the next available circuit, subject to convenience of the bench. Next.
Lordship.
I am for the petitioner, Lords.
I am for the state.
In this matter, Lords, there was a direction to submit the deficit court fee, Lords. We have done that. Lords, in this matter, Lords, the petitioners are three villagers
who, my lords, are challenging the new notification for a fresh vacancy in respect of a fair price shop. What the petitioners contend, my lords, is that there is already a fair price shop in Makpala. And this advertisement, if I can have my lordship for a moment on the advertisement itself. Very innocuous prayer, my lords, page 22 is the advertisement.
Page 20.
2222, my lords, annexure P1.
Now you are challenging this advertisement.
I just want a change of location. Because what is happening is, I will explain.
No, this is the advertisement.
This is the advertisement.
Now you are willing to apply based on this.
No, my lords. We are the beneficiaries. We are the beneficiaries. We are already collecting it from a place called Makpala.
You are the villagers.
We are the villagers. We are collecting it from a place called Makpala. Now our ration card is being detached from Makpala, and it will be, no, the second location is also in Makpala. So we say that we are all villagers of Kasiyabadi and Rajpur. The serving location here is at serial number 2, will also find the service area is Kasiyabadi and Rajpur.
Wait, just a minute.
So for serving the area of Kasiyabadi and Rajpur, another fair price shop dealer is being appointed in Makpala again. So our inconvenience is not addressed because we have to travel to 3.5
kilometers. This decision is taken based on your deliberation?
No, my lords.
Then?
There is already one shop that is already there.
Where?
There was at Makpala. At present, the fair price shop
it is the service area is Kasiyabadi and
yes,
and Kathalbadi.
Kasiyabadi, Kathalbadi and Rajpur. But the location
for the, is not in this.
That is the service area. But the location for the shop is serial number 1. Makpala post office.
Serial number 1 within the table.
Within the table, my lords, central location with road and para where the shop would be established.
Central location with road and para.
So that is the location where the FPS would be there. Now this, my lords, is at the same distance wherein the existing location is there. So we say give it to any vendor of your choice, but put it either in the village Rajpur or in the village Kasiyabadi. Because the ultimate aim is the door delivery of the ration scheme under the Food Security Act. Now, if our convenience is not redressed, and my lords, we have a mass petition also, which is here, which has been signed by 385 villagers. They all have the same agitation, my lords. That let it be in our village, either in Rajpur or, my lords, in Kasiyabadi. That is the only thing that the villagers want.
Yes.
And this has been explained, my lords, in paragraph number 8.
Petition is locus, my lords. I would say, what is the petition's locus here? They are saying on the resident of the villages, free resident of the village, and you cannot operate a shop there, my lord. And they come up with a lead petition regarding this. Challenge the notice.
They are saying that if the APS if APS will come up
in the service area
in Kasiyabadi, Katpala or Rajpur, then it will be far away from the problem which the petitioners are facing. That will remain unaltered.
Yes, maybe.
So therefore,
our current ration card is already with Makpala.
This APS is not will not come up in the come up at the area which would be convenient so for the petitioners are concerned.
The APS should come up in an area where the petition for the convenience of the petitioners or the villagers. But this particular villagers
in Makpala.
But this has to be
and this again is coming up in Makpala.
Public interest litigation.
I don't know. We are beneficiaries.
In the form of public interest.
We are beneficiaries.
Yes. 28.
Yes. 28 is the mass petition that has been signed. Sir.
We are 350 signatures. Neither there is no date to whom it has been addressed. Nothing is there. So it's in the form of here with the
Yes, how you are affected?
You are the direct beneficiaries. We travel 3.5 kilometers daily to collect
the government. Way to start
No, my lords,
a fresh FPS.
my lords, the
How will that affect it?
entire idea is the convenience of the FPS, those who are collecting the
Three
ration.
villagers are coming with a writ petition, no, not at the place A, not place B, but this shop should come
My
up.
lords,
at
paragraph 10 for a
on
moment.
what basis? Where is your right?
Paragraph,
Which right has been violated?
paragraph 10,
Requiring
no,
issuance of mandamus.
my lords, collection of this ration, my lords, from the national, it comes under the National Food Security Act. And there also it has been mentioned that it has to be at a location where it is convenient for the people. Paragraph 10, my lords, for a moment, page 9. What my grievance are? Let it be in the service area.
So have you raised any grievance?
My lords, these are all villagers, my lord, the mass petition
Where
has
is the
been signed.
This must, it has not been.
This selection of site must be on the basis of certain materials.
We are, that is not with
So
us.
you could have approached the concerned authority.
My lords, in that case, my lords, let my lords, my mass petition itself be considered as a representation. That can be done.
No, this is nothing.
That can be done.
Where is your mass petition and when it has been received by the authority? Show me.
No, my lords.
Show me page 28. When you have preferred and when the controller has received it, food controller.
My lords, let
Or
this mass,
substitution controller
let this be referred to the controller, my lords, for consideration.
Huh?
Let it be referred to the controller for
No,
consideration.
how you have served upon the controller?
If 300
Show me show me any acknowledgement.
My lords,
Show me any acknowledgement. Then I could have considered for referring the matter to the subdivision
my
controller.
lords, we will submit a fresh representation before the controller, my lords. Let him decide on a very compassionate ground, my lords, keeping in mind the distance that is involved. And particularly because the service area is not the village.
Where do you want? What would be the convenient site? So far
Yes, my lords.
petitioners are concerned.
In the service area, there are 3 villages. Let it be in any of the village.
Either Kashiawadi,
Or Rajpur. But not in
Katalwadi or
Makpala.
Rajpur.
Makpala, we are already going to Makpala to collect the ration. Our ration type
one more
detached
FPS
from
shop
there.
instead of for mom there is 2 FPS shop. Why are they affected?
Are Baba.
No, Are Baba, na. Why are you affected? You take
No, the distance remains same.
Affidavit of service filed on behalf of the petitioner is taken on. File your affidavit of service. Taken on record. 3 villagers.
Because the affidavit of service was filed at the last occasion.
What? 3 villagers are collected. 3 villagers have approached this court, comma, inter alia, comma, challenging a notification creating vacancy for fair price shop dealership. Fair price shop within bracket HPS dealership by the concerned state respondents. Dated 21st May 2025. Stop. In reference to this vacancy notification dated 21st May 2025, it is submitted by Mr. Mishra, learned advocate, that proposed site, SIT, proposed site of FPS dealership is at Makpala, MAGHPALA, where the service area, for service area, Kashiawadi, page 20, Kashiawadi, comma, Kathalwadi and Raj. In which district?
Kuchbihar.
Comma, in the district of Kuchbihar. Stop. Petitioners prays for issuance of direction upon the concerned state respondents to shift the site of proposed APS as notified on 21st May 2025 from Makpala to any of the places at Kashiabari or Kathalbari or Raj, which would be convenience so far petitioners are, which would be convenient so far petitioners are concerned to lift ration articles. Next paragraph. State respondents are represented by learned advocates and has questioned locus of the petitioners. Since they are not affected by the notification dated 21st May 2025, creating vacancy, creating a vacancy for APS dealership. Stop. Drawing notice to a document at pages 28 to 34 of the writ petition, it is also submitted that though a case, though an attempt has been made to file a mass petition signed by villagers, but there is nothing on record from which it can be ascertained that mass petition was submitted before the concerned authority for consideration. Next paragraph. Based on the materials available on record, it cannot be inferred that petitioners or similarly circumstanced villagers approached, who is the appropriate authority?
Respondent 2 minutes. The Director of Rationing Office. No, 2. Well, the notification is passed by the respondent number 3.
Approached district controller, food and supplies. Being respondent number 3. For creating a vacancy at a place which is nearer to the place of residence of the petitioners. / villages. Stop. Therefore, in absence of necessary particulars and materials, at this stage, no direction can be granted. Upon the no direction can be given upon respondent number 3 to reconsider the vacancy notification dated 21st. Who has issued this notification?
Respondent number 3 minutes. No, madam. The subdivisional controller. Subdivisional controller, food and supplies, Kuchbihar. He's not.
So respondent 3 is the higher authority.
Higher authority.
To reconsider the vacancy notification issued by subdivisional controller, food and supplies, Kuchbihar, dated 21st May 2025. Hence, writ petition stands dismissed. However, this order shall not preclude the petitioners to approach respondent number 3 for taking decision to notify a vacancy for APS dealership at a site which is nearer to the place of residence of the petitioner.
Get stop.
If any representation is made, court expects that same shall be considered in accordance with law by the respondent.
My lordship.
Urgent xerox of it. Next.
Lordship, I represent the state.
And for the petitioner, your lordship.
Yes,
It's the affidavit of service.
yeah, for the petitioner.
Yes, your lordship. Lordship, in this case, during the visit of.
Yes.
In this case, lordship, during the visit of PM, the petitioner had given some 60 to 70. In this case, during the visit of PM, petitioner has given 60 to 70 cars to escort, and respondent number 4 has
Petitioners are giving 60 to 70.
60 to 70 cars for the escort. And respondent number 4 has also given the car. And he was the driver of Innova Crista number WB76C0903. When the duty was over, the petitioner asked the respondent number 4 how many kilometer have your car run? He told that 1400 kilometer, but later on petitioner came to know that the car.
What is your prayer?
Police in action, your lordship.
Read the prayer, please. If anything can be understood from your prayer. What sort of drafting is this? Nothing can be ascertained from this prayer. It's devoid of particulars, devoid of facts, nothing is there. We do the writ petition, file afresh.
Lordship, this is entirely a private dispute.
Well, let them give a chance be given. Based on this writ petition, no order can be passed.
Lordship.
At the during course of hearing, learned advocate representing the petitioner praised for leave to do the writ petition with liberty to file afresh with better particulars. Next paragraph, state respondents are represented by learned advocates. Next paragraph, in view of efforts and submission made on behalf of the petitioner, writ petition stands dismissed as not praised or dismissed as withdrawn with liberty to file afresh with better particulars. Parties to act on the server copy. Appropriately drafted writ petition and file it. Yes, call the past one matter. Affidavit service to put it.
My officer even is present today.
My first query is whether the sketch map was supplied.
Not only the sketch map, that report even has not been supplied. Has not been supplied, my lord. And with regards to the second query, my lord, I know that is the second query that how the under the.
No, I understand your limitations also because it cannot be approved if it is not supplied. What can be done? Therefore, now the course which is left open is to supply the copy and revisit the issue.
That has to do.
Revisit the issue.
On instruction of the history engineer that it is not.
You are additional advocate general. You are not only representing the state. Your duty is to assist this court.
No, this is the reason.
Yes.
Because unless
So
verify the records.
In view of the order, your officer is there. Mr. Chaudhary, please come to this page 68.
68.
Copy of the page 68 of the writ petition.
Yes, my lord.
The copy of the said report shall be served upon the petitioner and the private respondent number 5.
My lord, it has shown to him.
And not only this, after this exercise was started by the authorities, then by sending a letter, petitioner prayed for supply of sketch map.
My lord, actually the supply which they have sought for to the BLRO before the BLLRO. But the proceeding initiated by this time under the Highways Act by the PWD. So the report which he is seeking from the BLLRO. BLRO,
but that report was forwarded to the engineer.
but they haven't
Assistant
approached to
Director
us.
and Officer in charge, Siliguri.
Right,
Yes.
but they haven't approached to us. To the PWD, they haven't highlighted that this sketch map was not. If your lordship see the addressing. My lord, at page 73, my lord. Oh, sorry, 79. Address to the BLLRO, my lord.
Page 77 is the letter, then 79 you are relying upon.
Yes, 78 million, this is the report. 78 is a report which the BLLRO had undertaken. And that report forwarded to the PWD, my lord. Right? And then, my lord, the next page 79, he has addressed to the BLLRO.
Sketch map and all.
Yes, my lord. But and which the reference of the, my lord, the memo, which the internal correspondence between the BLLRO and the PWD. Yes, received on 4th January. 4th January received the but what is the content? Sketch map has not, but we don't have any document to show.
So therefore, one thing is certain.
Reports,
that this
he received
report
the
is
report.
lying with the.
No, he received the report. One thing is certain, because also 79.
One thing is certain that this report is lying with the engineer.
And also he has received the report.
But after this order was passed.
No, my lord. No. Kindly see 79. Kindly see 79 once.
Yes.
Reference. Sorry, sir. Your notice such and such within bracket received on 4th January 2025. Before the hearing, my lord.
Page 79.
Yes, my lord. Sir. Just after sir,
yes.
Then reference. Lordship got it?
Yes.
And then your memo number such and such within bracket received on 4th January. So they have received the report. This is a report, which is below at 78. Which is received at 78.
But where is the sketch map?
This is, my lord. I cannot substantiate from my own records that this sketch map has been supplied. And my officer, the assistant engineer of the PWD, candidly said it has not been supplied. So, my lord.
So therefore, up to the stage of preparation of report dated 20 December 2024,
which was provided to him.
Not required to interfere because this was done in terms of the order passed by this court.
In presence of the parties.
Now, thereafter, this
the next part, report to be supplied.
The sketch map is to be supplied.
Report, not report. Definitely, report is the part of the all annexes to be supplied. That is page 68. Lordship, Honorable Court.
Yes. Copy of the said report shall be supplied.
The report definitely should come together.
Report as well as sketch map and other.
Yes, other. But report was supplied to him. But the sketch map annex, it has not been supplied to him. So we will revisit the issue.
Yes.
That is will passing the order. My lord will kindly consider page 95.
So one thing, just a minute. Let me clear myself.
Yes.
Before dictating the order. This is the order dated 19 December 2024. Then this exercise was carried out by the PLRO, who is Assistant Director and Official in charge, Siliguri Municipal Corporation. This is jurisdictional.
PLRO.
He served notice
on 2nd December 2024.
On 2nd December 2024.
Page 71.
And thereafter, this.
Thereafter, the inspection, the physical verification was undertaken.
Then this report was prepared
on
78.
78 page. Yes.
That is page 70, RS plot number 215.
He is under the occupation of the PWD land, highway land, along with the another 9 the occupants.
Now, this report was prepared and a sketch map was also prepared
because
based on inspection.
Because if you lordship see enclose the sketch map, bottom.
Yes.
Enclose the sketch map of encroachment area. Definitely there was a sketch map. So definitely when the sketch map was drawn and prepared, my lord, the private respondent had put their respective signatures. He is having a knowledge.
So therefore, let me set aside the order dated 7 March 2025, passed by the Assistant Engineer PWD, and I will direct him to revisit the issue.
17th March 2025, no, my lord, the 7th March 2025.
7th March, right.
Yes. 7th March 2025.
and direct the assistant engineer Shiliguri subdivision to revisit the issue.
No, my lord, we just, my lord, not revisit, because your lordship sees after the, my lord, the inspection carried out in terms of the, my lord, the honorable court's order. Now it was found that in the plot of 215 there are the illegal occupation. Now we have invoked section 10. Now section 10, my lord, that also is a wrong, my lord, because under the wrong presumption, because if the 10 they have not carried out, subsection 1, then subclause 2, the PWD should approach the magistrate. My officer approached the magistrate being the subdivisional officer. Subdivisional officer, instead of demolition or any further pursuance to the 10 subclause 2, issued that, my lord, the Unauthorized Occupants Act, that is 1962 Act.
But can it be done?
Should not. Cannot be done. So, my lord,
so therefore, the only recourse which is left open to the authorities is to rely upon section 10 of Section 64 Act.
Highways Act, yes, my lord, which I have handed over to your lordship. May I?
So therefore, the anxiety which is being expressed on behalf of the petitioner that two simultaneous proceedings, that is also addressed.
Yes, I have discarded. I said.
So only recourse which is left is under section 10 of 1964.
Can I place a document, my lord? After the 10-1 notice was issued, then my officer addressed to the SDO, I mean that magistrate, in view of 10 subclause 2. My lord, can you read? বইটা হ্যাঁ এটা জজ সাহেবের হাতে দিলে ও না সেটা তো আমার কাছে আমার কাছেই নেই অরিজিনাল আমি দিলাম
So your officer, that is the competent authority
under the highway,
that is competent authority under section 10(1).
Yes.
Under section 10(1), who approached the executive magistrate.
Because they have not removed the illegal encroachment. Then 10(2) has to be invoked. Then 10(2) is the magistrate. We have approached to the magistrate, being the subdivisional officer. Subdivisional officer, my lord, issued this Unauthorized Preventions of Act, my lord, of 1962. In place of invoking the 10 subclause 2. He ought to have invoked 10 subclause 2.
So issue has to be decided in terms of 10 subclause 2.
Issue to be decided, my lord, your lordship kindly see partial.
Already encroachment is
there. They participate in the inspection or inventory, my lord. Sketch map was drawn in presence of the private respondents. They put their respective signature, which ultimately the bearer prepared the final report. Report was supplied to them, but unfortunately, the sketch map has not been provided to them.
But according to you, as you are submitting, Mr. Chaudhary, section 10 subsection 2.
Yes.
Subsection 2, which says that if encroachment is not removed within the times specified,
that is 10(1) we have issued notice.
Then the highway authority or the officer authority, that is the engineer, executive engineer.
That SDO will direct us. The magistrate.
Highway authority or the executive authority under subsection 1 may make an application to the executive magistrate.
That we have done. That the document which I have just.
Where is that document?
That lordship, just the original document which I have handed over to you. Yes.
The subdivisional officer is the
magistrate,
executive magistrate. Now he has initiated a proceeding under section
1962 Act. Of 6, I think 3.
But that is not required based on the sketch map that executive magistrate could have.
Yes,
initiated the eviction process.
Only eviction ought to have been done by the magistrate. If would have done, the chapter would have been, my lord. Is a wrongly advised, my lord. I do not know how the, and I will correct it now.
Delay caused as
No,
a
because of the
result
lead petition.
that delay comes in favor of the petitioner.
Yes, because of this lead
Before the
petition, my
court of
lord,
law.
now the rectification would be made.
Yes, for removal of encroachment.
Yes, and my lord, kindly see the notice.
For removal and encroachment and delivery of possession of the land encroached upon the high authority.
My lord,
What
kindly,
what the subdivisional officer did, he just he initiated proceedings under section under the relevant provisions of 1962 Act.
yes, my lord, 88 kindly come back and
So now the exercise has to be done again.
Yes.
From the stage, this court need not go into that need not go to that far in order to examine the entire issue. Already a report has been prepared that is dated 20th December 2024, which is at page 78 of the petition.
and my lord, 7th March 2025.
Now I will direct that to
I will supply a copy within
the final order is to be passed by the executive engineer.
my lord,
And this order will go.
7th March.
7th March 2025 order will go, and the same authority, assistant engineer PWD.
my lord, the 7th March, your lordship kindly see, they have not addressed or agitated before the jurisdictional officer under the Highways Act that the copy has not supplied to them. Only they have sought for a report from the BLLRO. Had it been they have agitated this point, it has not been supplied to them, then your lordship could have thwarted this, my lord, this notice order of 7th March 2025.
But they have written a letter to the
BLLRO. He is not a jurisdictional, my lord. The competent authority under the Highways Act, when the hearing took place, he did not agitate.
So the petitioner ought to have approached assistant engineer PWD.
Jurisdictional, my lord, the officer under the Highways Act.
Issue.
My lord, page 95 and 97, my lord will find the.
Yes, your issues have been addressed. You need not dilate on this issue.
No, my lord. My lord,
Issue.
subsequently,
No
my lord,
further, Mr. Sen. Enough is enough. Enough is enough. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner is chiefly aggrieved by the order of assistant engineer within bracket PWD close bracket Siliguri subdivision Siliguri or Siliguri subdivision Siliguri subdivision dated 7th March 2025. Passed.
Well, may I hand over today right now?
Yes.
That would be better, kindly reflect it.
Yes, I will record it.
Yes. Only again it will be served.
PWD Siliguri subdivision dated subdivision being respondent number 4. Passed in terms of the order dated 19 November 2024 on a writ petition being WPA 2414 of 2024 preferred by the petition. Stop. Mr. Saurabh Sen, learned senior advocate representing the petitioner. Has challenged this order dated 7th March 2025 on 2 counts. First, prior to passing this order, along with the report dated 20 December 2024 prepared by Assistant Director and Officer in Charge, Siliguri Municipal Corporation area within bracket LR, being respondent number, which respondent
Bill Arrow, my lord.
Assistant engineer, yes. Respondent number 7.
7 is it.
Being respondent number 7.
Man, 7 has undertaken an inspection, Bill Arrow.
Yes, it's the assistant director and officer in charge.
Or Bill Arrow, yes.
Yes, jurisdictional.
Jurisdictional Bill Arrow.
Being respondent number 7. Being respondent 7. Sketch map and other materials prepared after inspection were not supplied to the petitioner.
No, my lord, only one sketch map. Only they have agitated sketch map, no other.
Other materials
if they want to rely on other materials, they have to supply.
was not supplied to the petitioner. Was not supplied to the petitioner. And where is the notice that two parallel proceedings? One is 64 and 62. Where is the notice relating under section 62?
Page 91.
Page 91.
Parallel proceeding under different act.
And two parallel proceedings are being run against the petitioner. One is under section 10 of the West Bengal Highways Act 1964, and another is under section 3 of the West Bengal Public Land within bracket eviction of unauthorized occupants close bracket Act 1962. 1962.
Mistakenly, wrongly 64 recorded.
Which is wrongly stated as an act of 1964 in the notice dated 28 February 2025. 28 May 2025. 28 May 2025. Stop. It is contended that relating to identical issue, two parallel proceedings cannot be, or no, two parallel proceedings may not be initiated against the petitioner. And petitioner was prejudiced for non-supply of sketch map prior to passing impugned order dated 7th March 2025 by the respondent number 4. Stop. According to the petitioner, in terms of the order dated 19 November 2024 passed by a coordinate bench, concerned respondent authorities were required to supply sketch map prepared based on inspection in order to point out that there was encroachment at the instance of the petitioner. Next paragraph. State respondents are represented by learned additional advocate general who has submitted on instruction that the report dated 20 December 2024 of the respondent number 4.
Respondent number 7.
Of the respondent number, assistant director, yes, of the respondent number 7 was supplied to the petitioner, but same was not accompanying sketch map, which was prepared by respondent number 4.
Respondent 7. Respondents were prepared.
Yes, jurisdictional, which was prepared by respondent number 7. After completing exercise in terms of the order of the coordinate bench dated 19 November 2020. Next paragraph. Furthermore, it is submitted on behalf of the state respondents that only recourse which is left open to the respondent number 4 and other state authorities is to take recourse to Section 10 of the West Bengal Highways Act 1964 and submission has been made in reference to the provisions as contained in subsection 2 of Section 10. Stop. Next paragraph. In the first writ petition preferred by the petitioner. Now, while disposing of the first writ petition preferred by the petitioner, video order dated 19th November 2024, jurisdictional block land and land reforms officer, as well as jurisdictional assistant engineer within bracket PWD, were directed to take certain steps. While perusing the records and on hearing the learned advocates representing the parties, it appears that steps were taken to demarcate the land in question.
Plot number 215, RS plot 215.
To demarcate the land in question within bracket RS plot number 215 close bracket by the respondent number 7.
7.
Being jurisdictional BL and LRO. And same was supplied to the petitioner. Stop. However, such a report was not accompanying sketch map before passing order. Sketch map, stop. Not accompanying sketch map, stop. Taking cue from the order passed by the coordinate bench dated 19 November 2024, it appears supply of sketch map was necessary.
Supply of report.
Supply of no sketch map
report.
No, report is there. Report
No.
is 20 November 20 December 2024.
As per the order, my lord, the report to be supplied. If your lordship see page 68 again, running page 3, that accordingly. Copy of the said report shall be served.
But you have prepared a sketch map.
That's that. But the order is that.
Supply of report was necessary.
Yes.
But it needs to be recorded herein that on inspection of the land in question, a sketch map was prepared, which was not supplied to the petitioner before passing
together with the report.
Before passing impugned order dated 7th March 2025.
Kindly indicate report together with this case.
Stop. Petitioner, by letter dated 13 January 2025, made a prayer before the respondent, made a prayer to the respondent number 7,
My lord.
for supply of sketch map. Stop. Next, however, fact remains, without supplying the sketch map, order was passed on 7th March 2025 by the respondent number 4, thereby depriving of petitioner from, thereby depriving the petitioner of making deliberation based on relevant documents which might have led the respondent number 4 to pass a different order. Stop. In addition, there are two for compliance of natural justice. Relevant materials, that is sketch map, needs to be supplied to the petitioner prior to final order is passed. Next paragraph. No, stop. Next paragraph. Stop. Non-supply of or failure to supply sketch map by the concerned state respondents vitiated the decision-making process. Next paragraph. Hence, order dated 7th March 2025, passed by respondent number 4, stand set aside. Stop. Next paragraph. Today, during course of hearing, Mr. Chaudhary has made over a copy of sketch map to Mr. Sen, learned advocate representing the petitioner. Stop. Based on, now stop. Petitioner is granted leave to petitioner is granted leave to file further representation to the respondent number 4 by 10 days from date, raising additional points, if any, in consideration of sketch map. Stop. Despite submission of representation in terms of the leave granted today, respondent number 4 is directed to revisit the issue and pass final order by 4 weeks thereafter. By 4 weeks thereafter, on granting opportunity of hearing to the petitioner or his representative. Stop. Stop. The decision to be taken by the respondent number 4 shall be communicated to the petitioner by 10 days thereafter.
I'll tell you one line, my lord.
Stop. Next paragraph. Concern which has been expressed on behalf of the petitioner that the state authorities are running two parallel proceedings. One in terms of Section 10 of the West Bengal Highways Act 1964, and another in terms of Another in terms of section 3 within bracket 1 of the West Bengal Public Land within bracket eviction of unauthorized occupants close bracket Act 1964 need not be dilated further in view of submission made by the learned additional Advocate General that only courts left open to the state authorities is to take recourse to section 10 subsection 2 or section 10 of the West Bengal Highways Act 1964.
If the 10(1) is not complied with.
I have stated that in terms of section 10.
Entertain.
That's why I have stated. Next. The writ petition stands disposed of or then.
Basically, one line, my lord, this fact has not been agitated to the jurisdictional, my lord, officer under the Highways Act.
Which fact?
This fact, that sketch map has not been provided.
আচ্ছা ও যেখানে চৌধুরী সাবমিশনটা হচ্ছে সেখানে একটা লাইন আছে but it is also submitted that non-supply of sketch map was not raised before
the respondent number 4.
Respondent number 4
in while passing, my lord, the order of 7th March 2025.
Disposed of
grateful.
Documents submitted in support submitted or documents filed on behalf of state respondents are taken on. I am keeping this book. We will get it back after.
So far as the documents that has not been supplied to me, man. That has been handed over to your lordship.
This is not required. This is not for you. You get the sketch map, may make a further written deliberation and then matter to be considered by the.
After, may I get back the original or afterwards, my lord? After the final correction. No problem. No,
next.
আরে অফিসিয়াল পেয়ে যাবি তো কোথায় করে যাবে
নাম্বার 78 একটা আনিয়ে নাও আনিয়ে নিয়ে এই এটা বই আনিয়ে নিয়ে দিই না
মানে let it be, no problem. কি এটা আরে 17 কোনটা এটা
মানে
সার্ভিস
proceeding under section 14 of the Surface Act has been initiated to seek.
We have DM has already taken step, within a month or 45 days we will dispose of.
Yes, the application is at page 108. 108 my lord.
করে দিচ্ছি তো আবার
These are steps to be taken under section 14
surface. First within 30 days, if not then another 30 days. Total 60 days time is there. But that has elapsed.
That we say that 45 days will come from today.
না বলতে বলছেন বলুন page 108 is your application section 14. It is to be decided by
district magistrate. Two jurisdiction, either district magistrate or the concerned chief judicial magistrate or the metropolitan magistrate, the case may be. So they have invoked the district magistrate jurisdiction to be considered within a 60 days. That is required to be done. Agricultural land না তো agricultural না তো
না না বাড়ি আছে
না বাড়িতে agricultural land করেনি তো
সেটা ডিএম দেখবে
তুই পাচ্ছিস
না সেটা ডিএম দেখবে
এই যে বাড়ি তাহলে বাড়িতে বাস্তুর পর বাড়ি ভেঙে যাবে
Subsection 1, clause 6.
And thereafter, semi. ওটারে বলে দিচ্ছি
হ্যাঁ মানে ক্লজ 9 মালট কি প্রভাইস কতদিনের মধ্যে করতে হয় ওটা ক্লজ 9 মালট
সিজিএম এর কাছে গেলি না কেন? কোর্টে দিয়েছে এখন সিজিএম এর কাছেই যাচ্ছে, সব সিজিএম এ যাচ্ছে, বেটার। সিজিএম সমস্যা তো সিজিএম এর কাছে দিলে পারবে, রিভিশন দিতে। হ্যাঁ, এই জন্য তো কথা বললেন, তখন সিও আসবে। হ্যাঁ, সিও, তখন সিও নাও এগেইন সিও হবে আর সিআরআর হবে। হ্যাঁ, আর ঠিক আছে, তোমরা নাম দিয়ে দেবো, একই করে দেবো। এটা তো অন্য কথা।
Who is representing the private respondents?
Only copy has been served, my lord. I've served. Every service is there.
When you have served?
My lord, on 21st July, it has been served. District Magistrate was served on 18 July. They are the necessary party, my lord.
Yes,
No,
that's
no.
why I'm asking.
I am seeking expeditious
If
disposal.
no creditor has come forward, where is the private respondents?
Because they are expeditious disposal only. The DM will take the decision.
No, but not behind their back.
My lord, I have served, my lord. Once you serve. Photo matter, I leave it to lordship consideration.
Affidavit of service filed on behalf of the petitioner is taken on the stop. Grievance of the petitioner being secured creditor under securitization and reconstruction of financial assets and enforcement of security interest act. This RPC Act of 2002 is non-consideration of application made under section 14 of the said act. Stop. In spite of service of notice, private respondents are not represented in this time. However, state is represented by additional Advocate General. Stop. Since next paragraph, having considered the submissions made on behalf of the parties present, it appears that the application made by the secured creditor, which is at pages 108 and 9 of the writ petition, is required to be decided by the district, by the respondent, by the district magistrate being Jalpaiguri being respondent number 1. Stop. By 30 days,
45 days.
Stop. Next paragraph. In view of pendency of this application under section 14, respondent number 1 is directed to decide the same in accordance with law by 6 weeks from the date of communication of this filing. Therefore, the decision to be taken by the respondent number 1 shall be communicated to the parties, shall be communicated to the petitioner as well as private respondents by
ministerial order.
But this need
no hearing to be given.
But the outcome.
Commit
Yes,
to be.
that is what I am.
That to be committed.
Yes. Communicated to the parties, communicated to the petitioner as well as private respondents by fortnight thereafter. Petitions can disposed of urgent.
Get full. Rest 2 are same, my lord. My
yes.
Rest 2s are same.
Next to a same.
Same. The other state advocates are the other.
18, I am the private respondent.
Oh, you are private respondent. My page 97 is my application. That I know though. That's what I said.
Oh, date has already been fixed.
Yeah, after filing of this application, that I have come to know from the private respondent.
Where is your application under section 14?
97. I instructed DM to immediately issue a notice to so that 18 and junior.
Same order করবে issue.
Only
Order
1819, my lord, not represented by additional advocate. Only that part.
অ্যাডভোকেট জেনারেল করবে না, মানে বলবে না স্টেট রেসপন্ডেন্টস আর রিপ্রেজেন্টেড বাই লার্নেড অ্যাডভোকেট করে দেবে। আর ওই পেজেস যেটা পেজ 97 পেজেস 1997 97 to 100
97 to 103.
103 whether the private respondents are represented.
Yes.
আচ্ছা, হ্যাঁ, this post
19 private respondent নেই কিন্তু
19 after the.
কোনটা 19?
you are for the state.
Yes, sir.
Where is your application?
Applicant 94.
Whether the private respondents are represented.
My lord, here, my lord,
When you have served.
my lord, I have sent, but the report says left. The address that was provided to us, we have served there, it says left. It was.
File your affidavit service.
My lord, yes, my lord. Endorsement is on of 18/7/2025, where it says that left. I have given the envelopes also, my lord. Photocopy of the envelopes. DM has been served, my lord, on 18th July.
DM is represented. Pages 94 to 100.
My lord. My lord, 94 onwards.
97.
Till 100.
97.
My lord, 97.
94 to 97 are affidavit.
No, 100 to 100. 100 till 100. 94 to 100.
100 crore. Private respondents are not represented. দরকার নেই, শুধু private respondents are not. এটা যেটা বলছি সেটা পড়ো না। Respondents same order করে দেবে, আর state respondents are represented by learned advocate, not by the additional application. Next,
Next matter, I am for the petitioner. If this matter be taken up tomorrow, my lord.
let it be called on.
My lord,
বল দে যে আমার বিরুদ্ধে সব দাঁড়াচ্ছিস কেন? কি বলবো, ও বলছে টাইম চাচ্ছে।
Yes.
A little preparation is required, my lord. Kindly takes it tomorrow.
Not tomorrow, then Wednesday then.
Wednesday.
Why? Tomorrow you.
Then it needs a little conference because I have.
Well, adjourn till 30th July 2025. No order.
Or the next circuit, you are not prejudiced in any
Take it
manner.
back. Take it back.
Huh? Next circuit করে দিই।
No,
not prejudiced in any manner.
হ্যাঁ, বুধবারই থাকবো, করে দিচ্ছি।
Next.
Grateful, lord.
The 21, I appear for the respondent number 3. My lord, I raise, my lord, extreme objection to the maintainability of the writ
Extreme
petition.
objection.
Yes, my lord, validity of the arbitral award has been challenged in this writ petition. Section 34 of the Arbitration and Conciliation Act is the only remedy. And my lord, arbitration between two private parties. How come the Union of India come to the picture? I do not understand.
I think my learned friend has not gone through the petition.
Very well.
And the prayer.
You let the,
And the prayer.
my lord, go through the petition.
And the prayer. Now, the challenge in this writ petition is as to only one point, whether deliberate and non-delivery of the arbitral award to the parties of the proceeding due to ignorance of law of the learned arbitrator tantamount to violation of constitutional rights or not. Because my right to appeal.
Well within section 34.
Because my right to appeal under section 34 is violated for non-delivery of the arbitral award.
Where is the arbitral award?
My lord, arbitral award they have not annexed.
I have not received.
They have not annexed the matter of arbitral award.
Now the question.
My lord, kindly comes to section 34, my lord.
One minute. Either you submit first or I will say later on. No problem.
What is the date of arbitral award?
My lord. My lord, the date of the arbitral award. Yes.
You are challenging the award in.
My lord, 18th July 2024.
I am challenging non-delivery of
that is a ground under section 34. That cannot be, my lord, executed under 226.
Award has not been furnished.
Not been served to the party. Now the question of law is whether it is mandatory to serve the award.
My lord, I am for the, my lord, private, I am for the respondent number 3. My lord, it is an arbitration between the partners or within, my lord, the Partnership Act. My lord, the learned arbitrator, my lord, where they appeared, they contested the arbitration and award was passed. And my lord, 4 of them, my lord, have been represented by one of the respondents, my lord, upon whom the arbitral award was served. My lord, that fact was also suppressed in this writ petition. My lord, the learned arbitrator has written a mail, my lord, to their client, my lord, on 20th of March 2025, annexing the track records that the arbitral award has been served. They have suppressed the entire scenario, filed this writ petition challenging the arbitral award. Whether, my lord, the
arbitral award was served upon the petitioner?
Yes, that the learned arbitrator, your lordship sees. My lord, they have written a mail to the learned arbitrator. My learned arbitrator has replied to their mail. Forwarded a copy to us from where we get to know this. My lord, arbitral award served, not served, arbitral award bad, good. All these points are grounds under section 34 of the Arbitration and Conciliation Act. Under no scope, my lord, 226 writ petition has the, my lord, jurisdiction to be entertained, your lordship.
This email letter was by the arbitrator?
Yes, reply to their email. They agitated the
this
point
arbitral award dated 18 July 2024 was supplied to the representative person who represented you. And irrespective of, despite of serving, non-serving copy of the award, it should be challenged under section 34.
No.
Why you are filing a writ petition? How writ petition is maintainable?
I will satisfy your lordship. That writ petition is maintainable for non-supply of the arbitral award to each of the party. Now the question of law, the pertinent question is whether each party to the arbitration agreement proceeding is obliged, it is mandatory on the part of the sole arbitrator to supply a copy to each of the party or not. Serving a copy on the learned counsel representing the party or to anyone who is representing the parties does not tantamount to
One
proper
Rajiv Ranjan Ojha was representing.
Yes.
For all of them.
Yes, my lord.
How the writ petition is maintaining?
I'll satisfy my lord. Just come to page 94. After I came to know from the pro forma respondent that an arbitration award has been passed, and he asked me to supply some document, I wrote a letter to the arbitrator.
No, whether you are represented by Rajiv Ranjan Ojha.
Yes, yes.
Before the arbitrator didn't matter.
Now the question is, that is the point of law your lordship has to decide. Come to page 9.
So,
let my learned friend answer to your lordship's question.
Yes, I will answer it right now.
Yes.
Please come to
affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. In the writ petition, one arbitral award dated 18 July 2024 is questioned.
Not the arbitral award, non-delivery of the arbitral.
On the basis of, please allow this court to pass an order.
Yes, definitely.
Even is questioned on the count, that arbitral award was not supplied to the petition or not, was not made available to the petition. Stop. Stop. It is submitted by, you are representing all the private respondents.
No, madam. Respondent number 3. The claimant in the arbitration, my lord 4, sorry, your lordship. 4, the my lord claimant in the arbitration.
I am for 1.
Respondent number 5. Learned advocate representing respondent number 4, being the claimant in the arbitration proceeding, has questioned the maintainability of the writ petition, whereby arbitral award is questioned due to non-supply of such award to the petition, to the writ petition. In support of such contention, an email letter dated 23rd July.
No, my lord, your lordship sees 20th of March. The learned arbitrator had replied to the my lord.
Email letter dated 20th March 2025 of the arbitrator is placed before this court, where from it and the same is taken on record. On perusal of such email letter dated 20 March 2025, it appears that one Rajiv Ranjan Ojha represented the petitioner in the arbitration proceeding before the learned arbitrator, and copy of the arbitral award was dated 18 July 2024 was supplied to him. 18 July 2024 was supplied to him. Stop. Taking note of the fact that the person who represented the writ petitioner before the learned arbitrator was supplied copy of the arbitral award dated 18 July 2024, and in view of the remedy lies under section 34 of the Arbitration and Conciliation Act 1996, no relief can be granted to the petitioner in the present writ petition. Stop. Hence, the writ petition stands dismissed.
My lord,
however, this order shall not preclude the petitioner. However, this order shall not preclude subject and writ petitioner. However, this order shall not preclude the writ petitioner to take steps in accordance with law in order to agitate his grievance before the appropriate forum.
My lord,
stop.
Kindly.
Deeply
obliged, your lordship.
Please to judgment may be deferred. I'm relying on this of the Supreme Court judgments. Now, 2005 Volume 4 Supreme Court cases. 237. 239.
Tekotrici, sir.
যেখানে ওনার সাবমিশন বললাম, in support of such contention, reliance is placed on the judgment of the Honorable Supreme Court reported in 2005-4 SCC 239 and another reported in 2012-9 SCC 496.
Now, here,
Next matter, please. Yes.
Your Lordship, Indian this may be given to just read out one paragraph.
Sorry, next matter. This is well settled. Yes.
Item number 22. Your Lordship, on item number 22, my senior Bhaskar Sengupta want to appear physically. Your Lordship, in item number 22, it is a WBGST matter. It is a second round of litigation in High Court. My senior Bhaskar Sengupta want to appear physically. I would pray for an adjournment for next circuit. You will kindly be prayed. Your Lordship, please be allowed for adjournment for next circuit.
This is item number 20. At a time of call, accommodation is prayed for on behalf of the petitioner. And prayer is also made to place the matter before the next circuit bench. Stop. Whereas state respondents, you are for
Yes,
state.
for the state.
State respondents are represented by learned advocate. Next paragraph. Acceding to the prayer made on behalf of the petitioner, hearing of this matter stands adjourned. List the matter before the next available, next available circuit bench, subject to convenience. Next.
Grateful, Your Lordship.
My Lord, item number 23, my Lord. Lord, item number 23, I am for the petitioner. My Lord, this is the matter for extension of recommendation in respect of upper primary selection. My Lord, I am working as an assistant teacher in 9-10 level. My Lord, a recommendation has been issued in my favor in respect of upper primary selection on 21st of November 2024. That is in page 17 of my writ application.
Upper primary selection.
Upper primary selection.
Yes, upper primary selection. You are selected in upper primary.
Yes, I am working at the relevant point of
SLST 2016 upper primary. You are selected.
Yes, recommendation issued.
Now, what you are praying for? If you are selected, then you are not, whether the recommendation was made.
Yes. Recommendation made. Appointment letter issued. No, my Lord, joined Pune appointment letter issued. But since I am working in 9-10 level, I could not join. But thereafter, after I am losing the job, I made a comprehensive representation before the School Service Commission that my claims, I want to join in upper primary level. That representation is pending.
When this recommendation was made?
My Lord, may I suggest?
Just a minute. It is his case.
Yes. My Lord, 21st November 2024.
Where is that recommendation?
Page 17, my Lord. Page 17.
Yes, why you did not join?
Well, at that time I was working as a 9-10. Well, I was working in the 9-10 as an assistant teacher, 9-10 level. Subsequently, panel cancelled. But I am only playing. Let my representation be considered if there is a vacancy is available. But they have to get the stand, my Lord, whether I may be.
What was the order I am passing in the sitting in the principal bench in the similar matter?
My Lord, say similar issue has been dealt. My Lord, your Lordship has been run last, my Lord. Last round, my Lord. In last round, my Lord, they have
direction for filing affidavit. You did not join at the material point of time in spite of recommendation. What can be done? Now you have lost the job in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025. Now, now this issue has to be decided on exchange of affidavits.
Well, led by representation, since my representation is pending, they have not taken any steps. Now the school is lying vacant. But they are requirement of the teacher. My Lord, if they exercise power under rule 3 rule 17 rule 3, my Lord, let them take a stand, my Lord, whether in several other cases, my Lord, they are extended the recommendation, my Lord.
My Lord.
Yes.
Yes. My Lord, kindly, if your Lordships kindly turns to page 17, the recommendation was made, my Lord, on 21st of November 2024. My Lord, thereafter, my Lord, first time, my Lord, petitioner prayed for, my Lord, made on representation before the School Service Commission on my lord, 16th of April 2025. That is, my lord, on the 147 days after issuance of recommendation. As per Rule 17.3, my lord, the recommendation can be, validity of the recommendation is for 90 days and which can be extended, my lord, not beyond 60 days. So, my lord,
Yes.
total 150 days. 147th days, petitioner made an application. Now, my lord, kindly turns to the representation which was made by the petitioner, my lord. My lord, this is not for extension of recommendation. My lord, page 20. Page 20 of the writ petition, my lord. 1, 2, 3. My lord, prayer for consideration and reissuance of recommendation letter for recruitment of assistant teacher for upper primary level. This is not made for the extension. Rather, my lord, this representation was made, my lord, may I fifth para representation. Therefore, I humbly request you to consider my candidature and reissue the recommendation and kindly inform the president such and such school to
Yes.
issue appointment letter for the same post since the said post is still vacant and no other counseling has been taken place for the same. It is not included a non-joining post from second round, second counseling to fifth counseling according to the vacancy list of the school displayed in the WBSSC website. So, my lord, petitioner never paid any application, never made any application or representation before the School Service Commission for extension of the validity of the recommendation letter till today, since the date of issuance of the recommendation.
So what is that page, page 20?
But page 20 is not for extension of the validity, prayer for consideration and reissuance of recommendation letter. Subject, my lord.
It may not be properly drafted, but the prayer is for extension of validity of recommendation. So you take a decision.
Only that much. Only that.
If your lordships can direct,
Now,
my lord,
when the period, 90 days period expired, 21st November 2024, December, January, February. So 20 February 2024, 2025, 90 days expired.
Yes,
And
my lord,
this application was made thereafter.
Yes, my lord. My lord, 150 days has already expired.
No. At this, when I made representation, that on
So
16th
first is
April,
90
150.
days, thereafter 60 days.
Yes, my lord. Within that
Under Rule 17.4.
Yes.
My lord, my lord, may I read
Rule
for your
17.3.
lordship? My lord, recommendation, a recommendation letter shall remain valid for a period of 90 days from the date of issue, provided that the regional commission may, if the expedient, to extend the validity of the recommendation beyond the period of 90 days for any reasonable causes, for the reasons to be recorded in writing, extend the period of validity of such recommendation letter for a period not exceeding 60 days. So, my lord, 90 plus 60 equal to 150 days. My lord, petitioner made the first representation on the 147th
But the
day.
petitioner has lost the job in terms of the judgment of the Honorable Supreme Court dated 3rd April. So under the special circumstances, you take a decision.
That much I am saying. That
Issue. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Stop. Petitioner has made a prayer for extension of validity of recommendation issued with a memo dated recommendation, extension of validity of recommendation which was issued with a memo dated 21st November 2024 issued. Now, which was issued by with a memo dated 21st November 2024 by the chairman, West Bengal Central School Service Commission. For her appointment as an assistant teacher in a government-aided high school. Stop. It is submitted by the learned advocate representing the petitioner that at the material point of time when the recommendation was issued, petitioner was working as an assistant teacher.
yes, assistant at 9-10 level. 9-10 level.
Petitioner was working as an assistant teacher on being selected in first state 2016 for classes 9 and 10. Stop. Subsequently, petitioner lost job in terms of the judgment of the Honorable Supreme Court delivered in civil appeal arising out of special leave petition within bracket civil close bracket number 9586 of 2024 within bracket State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee close bracket and others. Stop. After losing job, petitioner made a prayer for petitioner has made a prayer which would permit her to join the post of assistant teacher for upper primary section of a secondary school in terms of paid recommendation dated 21st November 2024. Next paragraph. West Bengal Central School Service Commission and the state respondents are represented by learned advocate. Stop. West Bengal Central School Service Commission is represented by learned advocate who appears on virtual mode. Petitioner is also represented by the learned advocate appears on virtual mode. Next paragraph. This court finds that petitioner was working as assistant teacher on being selected for the post of assistant teacher on being selected in first state level for the post of on being selected in first SLST 2016 for classes 9 and 10. Stop. However, petitioner lost job in terms of the order, in terms of the judgment dated 3rd April 2024, passed by the Honorable Supreme Court in Boishaki Bhattacharya Sutla, which compelled the petitioner to make an application dated 16th April 2025 to the chairman West Bengal Central School Service Commission for pending the validity of recommendation memo dated 21st November 2024. It is submitted that till date such representation or such letter dated 16th April 2025 has not been responded to. Next paragraph. In consideration of the special case where petitioner has lost job, Chairman West Bengal Central School Service, Chairman West Bengal Central School Service Commission, being respondent number 3, is directed to decide the application of the petitioner dated 2nd July 2025 by 4 weeks from the date of communication of this order. Stop. Decision to be taken by the respondent number 3 shall be communicated to the petitioner by 10 days thereafter. Read petition stands.
My lord, representation 16th April, my lord, page 20, 16th April.
16th April.
Yes, my lord, it is a comprehensive, which is within 150 days. Your lordship said my last representative 2nd July. Page 20, 16th April, which is
16th April.
Yes, is within 150 days, which is lordship. I am extremely grateful.
16th April 2025.
Great.
Yes, call the next matter.
Your lordship, senior advocate is on the virtual mode.
Article 24, I am for the petitioner, madam.
All parties are present?
Lord, I am present, but the instruction is needed. I already sought for the instruction.
Not today.
You know, instead of not today, kindly make it not tomorrow.
Come back tomorrow.
Private register has not been sought yet. I have said.
Why it has private respondent has not been served?
I have said, but postal receipt says it has not yet been
When it
delivered.
will be called on, remind me, I will pass on.
As well.
জানি এবার না তাহলে বোথ সাইড না থাকলে হবে না কি হবে
Item number 25.
But, please have action, Lord. This is with respect to, my lord, setting up of a rice mill. I'm sorry.
all parties are present, Mr. Chatterjee?
Yes, my lord.
You are for the state, who is for the WBPCB?
Mr. Saha. Court has appointed, Mr. Lord, your lordship will find, my lord, that this matter
Mr. Momin.
has a little bit of a checkered history in the sense, my lord, and arbitrariness of a different level has happened, my lord, in this matter with respect to the petitioner. My lord, the petitioner is the lessee of a land which is recorded, my lord, as a rice mill. It was done after, my lord, proceedings under 4C, my lord, was carried out. My lord, the entire process is for setting up of, my lord, of a rice mill. My lord,
Why it is appearing under the heading motion?
my lord, it was always appearing as motion. My lord,
There
only
was
a
no
report.
direction for exchange of
No,
affidavits.
reports were sought for, my lord, and we have, my lord, and that would be sufficient for, my lord. Because it's a question of law, facts, my lord, are all admitted, my lord, before your lordship. I don't think, my lord, even the Pollution Control Board, my lord, who was really, my lord, against me, my lord, at the time of initial hearing, even they would object to that, my lord. If your lordship sees, my lord, Justice Hiranmoy Bhattacharya's order at, of, my lord, 9th of April, 2025.
So response number 5 was directed to file a report.
Yes, but both of them, not just 5, not even the pollution control. I'll give your lordship, give me
Now,
2 minutes.
it's a matter relating to the issue whether the paraboiling unit can be made functional or not.
Yes.
Within this
Within
forest
the
area.
Forest area.
Forest
It is not within the forest area that these forest authorities have told your lordship. What they are saying, my lord, it is within the eco-sensitive zone. The Pollution Control Board, my lord, is now saying, get a no objection from the government for setting up that boiling unit, my lord, within that eco-sensitive zone. He's right. I made a mistake there. Consent to establish was granted by the Pollution Control Board in 2022. In terms of that consent to establish, my lord, I have established every, my lord, possible part of the factory, and it is there, my lord, under the sky, ready to operate. Once, my lord, I went to them to give me the consent to operate, they say you go and get a no objection from, my lord, the government, the forest authorities. So I went to the authorities, my lord, the authorities sat there and said that this falls within the eco-sensitive zone, and they have applied before the central government in 2023 for, my lord, revision of that entire eco-sensitive zone. And that is why, my lord, they have not even considered, my lord, my representation at all.
So issue is pending before the central government.
That is what the government is saying. I am saying, my lord, the question doesn't even need to be referred to the central government at all. Why? My lord, Pollution Control Board says that new hotels and resorts cannot be set up. Industries can be set up. Non-polluting industries which are within the orange zone or, my lord, the other zone can be set up.
So who will certify that it's a non-polluting industry?
But the Pollution Control Board, they've certified it. And that is why we've established it.
No, but if it is in the eco-sensitive zone,
My lord, when we established
that identification of eco-sensitive zone has to be ascertained from the central
that the
government.
forest is saying, my lord, takes up the report, your lordship will see, my lord, it is beyond the forest zone. Takes up the affidavit of the forest authorities.
Then array the central government as a party to.
They are there.
Who is representing the central
My
government?
lord, if your lordship
You have said that all are
my lord has
represented
my lord has seen, my lord, the order of justice, the Hiranmaya Bhattacharya.
Just a minute.
Pollution Control Board.
Under the state, not central.
No, because it was Tomra Bolecho, you have sent it. to the-
Principal Chief Conservator of Forest and Chief
Yes.
Conservator of Forest,
Yes.
but the central government has not been made.
No, but the Pollution Control Board, my lord, was asked to, my lord, file a report.
But at the same time, as
No,
you have
I am-
submitted, Mr. Chatterjee, that
Right.
that the issue needs to be decided whether the no objection is to be issued or not.
No objection
Based
to
on
be given by them.
based on identification of eco-sensitive zone or the area of
I'll tell you.
eco-sensitive zone
Well, I-
by the central government.
Not the central government. It is the monitoring authority of the ESZ. The monitoring committee, my lord, which is represented by my learned friend, senior friend as well. And they are parties to your lordship's proceeding. I'll gives me 1 minute's time. I'll try and take your lordship back to from where, my lord, it started off. Because what happens is in 2020, my lord, your lordship takes up the writ petition once. Takes up the writ petition. I'll show your lordship how, my lord, I have been, my lord, hoodwinked into, my lord, this entire situation by the state authorities. Kindly see, my lord.
Only first of all, it has to be find out that whether it has to be found out that whether this what is the area of eco-sensitive zone?
Absolutely.
Whether your unit is coming within the
It's all
ambit
there in
of
the report.
eco-sensitive zone or not.
It's in the report. My lord, I am saying, even if your lordship finds it's within the eco-sensitive zone, hotels and resorts can't come up, but industries can come up if it is within the orange or the body below the another color is there.
So according to you, Mr. Chatterjee, that the hotels and resorts is more pollutant
That's what they have said.
than the industry.
That's what they've
Who
said.
will believe it?
That they've said so. My lord, it's on record. It's on record. I'll show your lordship. It's very interesting, my lord, in a sense. They have said, using, my lord, 25-26 of the Water Pollution Control Act, no new hotels and resorts can be brought up. But if I'm an orange industry, my lord, it can be set up. And that is why they gave
It
consent.
can be set up in eco-sensitive.
Yes, and that's why they have given me consent to set up.
But
establish
that then what role is to be played by the central government?
nothing. That I'm saying so, my lord, nothing for the moment. Because
the
the
pollution
state-
control board has said that it depends upon the decision of the central government.
No.
Just you have submitted.
No, I probably am. I was wrong. They said that we want to review the eco-sensitive zone. If X is the eco-sensitive zone, they wanted to shrink it to Y. That they have to do.
Whether that shrinkage is permissible.
Yes, whether it's permissible and it can be done.
Yes,
Mr.
Mr. Chaudhary, whether it is permissible.
But it can be done with the approval. of
Limiting
central
the eco-sensitive zone in order to accommodate paraboiling unit.
May I just for 1 minute?
But I would need a
Just
Yes,
1 minute.
allow him.
Judge have
Malad-
tried it straight.
Well, what happened? This unit initially it was earmarked within the 10 kilometer, the ASJ. Then subsequently, after the order of the Honorable Supreme Court to review the matter, it has been reduced from 10 kilometer to 5 kilometers. Now, my lord, within the 5 kilometers, this unit falls. Now thereafter, what happened pursuant to the review petition filed before the Honorable
So
Supreme-
this unit falls within this radius of 5 kilometers.
Well, yes, today, as of now, today. Then review petition filed before the Honorable Supreme Court. Then this Honorable Supreme Court said it cannot be in a straitjacket formula for 5 kilometer. Case to case basis. you have-
Varies.
Yes, it may be 0 to 5, 0 to 1. So, Milord, we have proposed a revised draft proposal sent to the central government, reducing the area from 5.
Which authority has proposed the revised draft?
ESZ monitoring committee.
Monitoring committee.
By district magistrate is the chairperson of the said monitoring committee. The pollution control board is also one of the party. Now, what happened in this case, Milord? When this consent to operate establish was given, the matter was not placed before the Milord, the ESZ monitoring committee. So the ESZ monitoring committee was under the DAR. Now, Milord, the pollution control board has given such power or the permission to such, Milord, the establishment of this unit. Now, the moment it has come for our operation, Milord, then the pollution control board said no, it require a ESZ, Milord, the NOC, or as it falls within the forest region of the area, so forest should give also NOC. There was a little, Milord, the confusion. Then, Milord, this is the reason forest, the high officials were included, added as a party, Milord. So they submitted an affidavit because initially I said also that it do not fall within the purview and limit of the forest area, Milord. So this unit excluded the forest area. That by an affidavit it said. Now the difficulties of the, Milord, the ESZ monitoring committee, neither it was placed before us. The consent to establish was given. Now by the affidavit.
Consent was given by the state.
By the
pollution control.
Pollution control board. Before giving such permission, it ought to have placed before the monitoring committee. Monitoring committee ought to have said that this is the reason it cannot be given or can be given. Nothing. Now it has come. What we have done, we said in the order, because in view of the Milord, the court bench order, Milord, the hearing was given. Then in the hearing we said the matter was placed before the Milord, the climate change, environment or forestry, Milord, for reducing the Milord, the area from 0 to 5. That is under, Milord, the
or 5 to 0.
Yes, 5 to 0. Sorry. Sorry. And before the Milord, the concerned authority, and draft publication hasn't come. If the draft publication has come, then definitely, Milord, they have a right to object, or Milord, on the basis of such objection, then final publication.
So which authority is the
now the PCB filed an affidavit.
Appropriate authority.
Now PCB said by an affidavit, though my under one state's organ, I'm not representing. PCB said by mistake we have given. My Lord, affidavit said. Now, my Lord, what am I supposed to do?
What am I supposed to do?
My difficulties is that
no, but the court is concerned about the maintenance
but Milord,
of the system.
if it is
pollution-free atmosphere.
Yes, if it is a orange zone,
even if it is by way of mistake, that cannot be given a stamp of approval by this court.
But even Milord, if it at best, Milord, the orange category of industry, Milord, what is the notification of the Milord, the pollution control board? That they said already it is functioning, then they will not touch. New unit, if it is a orange zone, then the prior permission or consent is required. That
prior consent of
the pollution control board. Pollution control board. Pollution control board given a for an establish right to establish, Milord. Now, while granting a consent to operate, they said no, it cannot be given. Only the ESZ monitoring committee can be given. So, my Lord, ESZ committee neither considered this application while granting such permission to start or establish. So, my Lord, the question, even we said that
now whether while deciding the issue, representation on behalf of the central government is necessary.
Representation.
Since you have forwarded representation. On
it is a natural course, my Lord. It is a natural.
Since you have forwarded the draft proposal to the.
When the 5 kilometer was published, the central government definitely is the empowered to publish such notification. The central government published that 5 kilometers. In the review application, matter came, and then we forwarded the matter on a basis of case-to-case basis. Suppose now there is a forest village. There are certain the other establishment. Then bifurcating, there is also a road. So these are the considering this aspect, it has been sent back to the government of Union of India, Forest and Climate Change Department for considering for publication of the final proposal of the draft proposal from 5 to 0.
So that is pending before
pending before the Forest and Climate. This is the
Mr.
situation.
Chatterjee, let it be ascertained from the central government,
Right,
what, how they are
it's in 2
responding to
minutes.
their draft proposal.
But it's draft proposal, I'm saying.
Issue is very
without it-
sensitive. In a,
That's
in
exactly
a
what I'm
simple
saying
manner,
is
issue cannot be
it's
dealt
not
with.
sensitive. It's not a question of law and a question.
Which one is the appropriate authority?
PCB.
Central government?
No,
Central
no,
government?
but the climate change.
But if your
There
logic
is a department of climate
Yes,
change.
environment and climate change. But shall I give you the full name?
if your logic gives me 5 minutes time, I'll try and explain to your logic why it's probably not necessary. No, I don't have a problem with the central government being arraigned as a party.
So your, just a minute, your proposal is for limiting the
If the
eco-sensitive zone,
if it is published, Milord,
for limiting the eco-sensitive zone, if that is approved by the Environment and Climate Change Department, then you can.
Because now this unit, when the draft proposal has forwarded, this unit is now outside the purview of ESZ, if it is approved. Well, candidly, I must say that this is the situation of the ESZ monitoring committee. As
So
of
if
now,
this draft proposal of ESZ is approved by Environment and Climate Change
then it
Department,
will come with
then you have no role to play.
it will come outside the purview of ESZ.
Nobody will have a role to play.
It will
Because
come.
it will be limiting from 5 to 0.
Yes. Now today is
I am
5.
saying,
But if it is restricted to 5,
Then
in
it
that
falls.
event, the
It falls.
petitioner is not in a position to
No, nothing.
make
Nothing.
this
ESZ monitoring committee.
paraboiling unit functional.
Parabolic.
no,
Malat,
it could not be functional, Milord, because the consent has not come before me.
From the PCB.
it has not. It is not
Milord,
functional.
gives me now 5 minutes time. I'll give your lordship a little bit of history, Milord. Your lordship, I'll till 4:30 Milord, should be able to finish. Milord, kindly takes up the writ petition.
I will hear you 5 minutes, not 4:30. Yes.
Takes up the writ petition once. Kindly takes it up, Milord. 4 documents I'll show your lordship, and then I'll take your lordship to the reports. And what
But
if
at this stage, in this fashion, without calling for affidavits and without central
there was an
government,
affidavit.
I will not
affidavits
exercise.
are on
Take
record.
such exercise.
Kindly
Sorry.
take PCB's affidavit.
Milord, the affidavits are on
Report, sorry,
record.
PCB's
Issue,
report.
issue.
PCB report at page.
The affidavits are on record. Kindly,
Matter relating to making a paraboiling unit functional.
Milord,
within
it's a rice mill.
Rice mill. It's not a paraboiling.
No. We need a parboiling rice mill.
Rice mill.
Seddho bhat, basically.
There is a PDS system to facilitate the PDS system, Milord.
Seddho chale,
PDS system ke place.
That's why, Milord, I was just seeking 5 minutes of my lord's time. If your lordship grants me that, Milord, before your lordship, Milord, starts dictation. I'll make it very, very simple for your lordship.
Lordship, what is the PCB's affidavit?
No.
My lord needs the PCB's affidavit, and my lord needs the forest's affidavit. 2 affidavits your lordship needs, Milord, before your lordship. দে না জজ সাহেব, ওখানে ফাইলে তো থাকার উচিত। তোমারটা দাও না।
হ্যাঁ, কি বলছো? Parboiling unit functional.
Not functional.
It is not functioning,
No,
but
no.
you are praying for making the same unit.
I'm not even praying for that at the moment, because I need the consent to operate, Milord, from the PCB. Everything has been done, Milord, in terms of law and what the authorities wanted me to do. Milord, today, if your lordship takes up the forest officer's, Milord, affidavit once, and also sees, Milord, Justice Hiranmoy Bhattacharya's interim order.
Parboiling. With the assistance of Pollution Control Board, within bracket PCB, and Boxer Tiger Reserve Eco-Sensitive Zone Monitoring Committee. Stop. Mr. Chatterjee, learned senior advocate representing the petitioner, prays for a direction which would permit them to make the unit functional. But it is submitted on behalf of, it is submitted by Mr. Joyji Chaudhary, learned additional advocate general, representing on behalf of Boxer Tiger Reserve Eco-Sensitive Zone Monitoring Committee, that a proposal has been mooted and forwarded to Environment and Climate Change Department,
Ministry of
Ministry of Environment and Climate Change, Government of India. Achha, the Ministry of Environment, Forest and Climate Change. Government of Ministry of Environment, Forest and Climate Change, Government of India, for reducing the radius of eco-sensitive zone from 5 kilometers to 0.
Yes,
That's
the
the
review thing, my lord, which they have given. I don't have a copy of that. That's
For reducing the radius of 5, yes, Mr. Chaudhary,
Yes, my lord.
from 5 kilometers to 0.
Yes, my lord.
No, my lord, they haven't said that also. If your lordship sees the minutes of the monitoring
From
committee,
5 kilometers to 0.
I
And the
haven't
issue
said
is
that.
pending before the said ministry.
Pursuant to the, my lord,
Stop.
this
It is-
judgment of Godavaram Tirumal.
Stop. It is also submitted that though initially PCB or Pollution Control Board, State Pollution Control Board granted permission for establishing parboiling unit. But subsequently, it was intimated to Eco-Sensitive Zone Monitoring Committee that by mistake this was.
no.
No,
My lord, the affidavit, affidavit,
না, তাহলে এটা রেকর্ড করো না, he will be notified.
but it's on my stand. If
কেটে দাও, না, কি বলছিলাম? না, it is also submitted. Stop. Next paragraph.
Lord, what was
Since
communicated
there
to
is no
me?
response from a ministry of all, so and so ministry, based on the draft proposal forwarded by the
monitoring committee. Boxer Tiger.
Eco-Sensitive Zone Monitoring Committee. Issue at this stage ought not to be decided. Stop. Next paragraph. Leave is granted to the land advocate representing the petitioners to amend the cost title and add. What is the department?
But it's a ministry, government of India, maybe.
That
Government of
department.
India represented through the
Ministry of Environment and Climate Change, Forest and Climate Change.
Union of India represented
represented by the ministry.
The proper party would be secretary to the department.
No, ministry though, Union of India represented by the ministry. That's how we add below when the Union of India is appearing.
The department, ministry.
Or leave is granted to the petitioner to amend the cost title and add Department of Environment, Forest and Climate Change.
Government of India.
It's a
Government of
ministry.
India as additional respondent.
But it's a ministry, not a department. It's a ministry.
That's why I said, my lord, the department secretary to be represented, the Union of India of this department.
Union of India is the party represented by the ministry.
Yes.
That should be, that's how the writ petitions are always drafted.
System is that a concerned department should be made party.
In the ministry and then the ministry will say, my lord, what department and things like that. But the ministry is below the person who's responsible.
This is the ministry, not department. This
is a
forest, climate and ministry of, this is the Ministry of Environment,
Like,
MOE.
the Department of
Leave
Telecommunications.
is granted to land advocate representing the petitioners to amend the cost title and add
MOE.
Ministry of
Environment.
Ministry of Environment,
Environment,
Forest and Climate Change.
change.
Ministry of Environment, Forest and Climate Change.
Better to add Union of India as well. नाले पढ़े क्या
And its secretary.
Yes.
And its secretary as additional respondent.
If I can add the Union of India, then everything.
Leave is also granted. Otherwise, complication may.
Yes, yes, that's why.
Leave is also granted to the learned advocate for the petitioner to add Union of India as another additional respondent.
From 2022, I'm not suffering.
After such amendment is carried out, a learned advocate for the petitioner is directed to serve copy of this writ petition and reports filed in connection with the present proceedings and the order passed by this court today to the additional respondent by 3 weeks from date.
No, I'll take just 1 week. I'll kindly direct me to serve the additional Solicitor General. I'm suffering from 2020.
But in addition, thereto it has to be solved.
I will serve. I will do it within a week. I will do it within
by fortnight from date. By fortnight.
Because the next circuit, I kindly direct the matter.
By fortnight from date. Stop. In addition, thereto
Fortnight, the next circuit will be earlier.
In addition, thereto learned advocate representing the petitioner is directed to serve notice upon the learned additional
Deputy Solicitor.
Learned Deputy Solicitor General
of India.
Stop. Next paragraph. An affidavit of service to be filed on the next day. Next paragraph. List the matter under the heading hearing.
Motion. Lord kindly keeps it under. All throughout it's been under motion. Lord kindly keeps it. Kindly. Lord, I'll tell your Lordship, Lord, there are 200 workers who are waiting in the wings. The entire locality is stopped. Kindly appreciates this.
What
2022, Milord,
after filing so many reports.
Just reports. And I will tell your Lordship, it's only on law. Nothing to do with facts. Facts are all admitted. Whatever my learned senior friend has said, whatever the Pollution Control Board has said, everything I'm admitting.
Representation comes from the union.
My lord, let it remain as
Is
motion.
the matter under the heading motion.
On the first day of the circuit, if it's possible. Well, my exception may be kept on record.
Exception,
I mean,
copy.
Ah. PCB.
I have a copy also. For my consumption.
During the second week of the next, during the second week of the next available circuit, subject to
convenience.
Second week, then we are again creating a problem. I will
let Mr. Chatterjee, let the representation come.
What I'll tell you, Lordship, Lord, initially
I understand, I appreciate your concern, but at the same time, the representation.
No, I completely bow. I'm not even trying to do something very hurriedly, because this will really needs consideration on both sides, not just the environment side, but also the commercial side as well. So both sides, equity has to be done, by
and you know very well when the union is made party, how much time is required.
But I will try and make sure that is curtailed as far as possible. My exception to the Pollution Control Board's report. Maybe
how many exceptions you have filed?
Just one. Because the state has given.
Add a line. Exception filed in the form of affidavit.
No, my lord. Just
exception filed to the report filed by Pollution Control Board, State Pollution Control Board is taken on record.
So grateful to you.
Copy may be also.
Serve copy. Serve copy upon the learned advocate. Your exception to be served.
Lord, the union is here, but I will reserve right now.
Where is the union?
Yes, call the next one.
Here is
Great, sir.
Your lordship, I think, may I leave?
Yes, it is up to you. Your resolution, whether you will follow it or not, is up to you.
Thereafter, no matter is,
It's up to you. Court will call all the matters. If all parties are not present, court will adjourn the matter. Your resolution, you will follow or not, it's up to you. It is not nothing to do with the bench.
I don't have any plan.
Yes, item number 26, who is appealing for the petitioner? Not today, next.
27.
Not today.
28.
Go on calling.
29, 30, 31, 32, 33, 44, 35, 36.
Item number 21, by the closure for private.
Not today, petitioner is not there. Yes. Next.
37, 38, 39, 40, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 60, 54.
I'm for the petitioner in 54.
All parties are present.
No, the question is, there was an order to.
Viral, I will hear you in presence of other side. Today, there is a resolution by the, of the
Only
bar.
affidavit.
Not today, not today, not today.
7, 8, 9, 60, 51, 52, 54, 55, 56, 57, 68, 69, 70, 71, 72, 73, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 106, 103, 104, 105, 107, 107, 108, 109, 110, 111, 113, 114, 115, 116, 117, 118, 119, 120, 121, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132, 132, 134, 135, 136, 137, 138, 139, 140, 141.
ওটা সারা ইয়েন হয়েছে বুঝলেন তো বুঝতে পারলাম না প্রথম করে দেখে বলি বা কি করবো কোন রেজিস্ট্রেশন ওখানে লোকাল রেজিস্ট্রেশন হয়েছে নাকি করছে সেটাই বললো আর 21টা বুঝতে পারলাম না ফট করে তোমার বেরিয়ে গেছে উপরে ক্লিক করো এমনি আউট হয়ে যাবে নাকি